Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Is that correct?
Dati mihi Anglican police are but I didn't ask you to interrupt me. Also from safe.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Welcome. Oh, I've got the hearts on. See the hearts flying up on the screen. I have to turn the hearts off on the screen because it covers up some people's chat and it makes it just depending on what device they're watching on. So get your hearts in now. Get all your clicks. Get your little taps in because I got to turn it off. Okay, here we go. I've seen smiley faces, hundreds, hearts, everything else. All right, thank you all. Britt Bottoms, I just saw your comment. Hang on one second. Let's see. Boom. There they go. Oh, bye-bye, hearts. All right, thank you. Welcome to the Court of Public Opinion. I'm the Recovery Addict. I also want to say welcome to Britta, who is not appearing on screen for some reason. Just one second. Let's try that again. There she is. All right. Buttons are working again. Britta, congratulations. You were first in chat this morning. Happy Friday to you. No pants Friday, by the way. So I've got the screen appropriately cropped to the right area. But I was wondering why you didn't have the hearts option. I just have a lot of people say, please, can you please turn off the hearts? Because it goes over the text for them. Like if they're watching on the TV and the text is on the right-hand side of chat, it makes it hard to read chat. And a lot of people, rightfully so, love the chat, probably more so than the content on screen. So I do try to make sure that the community can communicate with each other instead of just spam the heart button, which I appreciate as well. So thank you. All right, Britta, internet's all yours. Keep it running for us today. I have to say that it looks like most of the ice storm is over. We're in a little bit of a warming trend now. That might be better for the internet as it thaws out. So congratulations. Kate Tastrophe, member for 7 months, says, woohoo, 7 months. Love this community. Thank you, Kate. Congratulations. I love the name, by the way. That is just awesome. Appreciate you being here. Wouldn't be the same without you. 7 months. 7 months. Woot, woot. All right, it's Friday.
My new best friend.
Yeah, there we go. Thank you. You're my new best friend. It's Friday. I was so excited you guys let me participate in Bring Your Wife to Work Day yesterday. It was awesome.
Birthday.
I loved.
You look good.
I loved having Mrs. R.A. on with me. As you know, she's my hero. I married up. She tolerates me somehow. I don't know how, but I appreciate all the support you showed her way as well. So, thank you. All right. Emily, I saw that. I've got your text right here right now. It's on my screen. I saw that. Is that case televised somewhere?
Subject matter jurisdiction.
It's a wild one, but it sounds like murder for hire, but they got the wrong person. Is that what I read from it? All right, we have buffer sounds. Hopefully the buffers are working. Izzy's mom. Oh my goodness, you missed a day and a half, all within one day. We have birthdays here to take care of. You have to take care of the birthday people. It's their special day. There we go. Let's see, Kristen Sinbad, Sunseeker. I'm not trying to elevate one above the other. This one right here, I'm going to have some Andquelek. Is it Andquelek? Was that close enough? I struggle with the names. Let me see if it's somebody help me with the Andquelek name. Spell it out phonetically for me in chat. Is it Andy Qualek? And needs a space. Oh, just Qualek and not okay. I got it, Josh. Thank you. You had me concerned. I'm like, I don't know that name. All right, I probably should have figured that out on my own. Josh, thank you very much. Okay, so we've got. If we can post it one more time. You saying the names is the best part. Post it one more time.
Happy
there we
birthday.
go.
You look good.
Because I will say Aunt Qualek in the birthday song is the problem. Because in the heat of the moment, as I'm mid song, I struggle with reading and even more so with pronunciation. So just Qualek. So we're just gonna sing to Qualek. What about the other? Did the other two's birthdays not happen? Here we go. Kristen, Sinbad, Sunseeker, and Qualek. Josh, thank you. I torture you guys just a little bit. Thank you. That's the specific format I needed it in. Thank you very much. Here's what we're going to do. Everybody stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbors, warm up with me if you will. La 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 la. I think it's going to be a good one. We're going to sing to Kristen, Sinbad, 33, Sunseeker, and Qualek. Happy birthday to you. Happy birthday to you. Happy birthday to Kristen, Sinbad, 33, Sunseeker, and Qualek. Happy birthday to you. It's funny, I had to take the and out, but I said it anyway. What's with that? What's with that? So you might have had it right in the first place. Kristen, Sinbad 33, Sunseeker, Qualek. There you go, I just did the comma. Today is your special day. I realize there are a million places you could have been, a million people you could have celebrated with, but you've chosen to be here with us. The privilege and pleasure is ours. Please allow us to return some of that wonderful, wonderful feeling back to you and make your day a little more special. Help yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, and Bob Evans. And I think there's a free burger at Red Robin. Don't quote me on that one, though. Don't quote me on that one. Dancers doing a good job doing the birthday dance with the high kicks. Jennifer, I think that's a peach. I think that's a peach. She's shaking it. That's all I can say. She's shaking it. If it's a peach, she's shaking it. She's dropping it. Yeah, like it's hot. Red Robin gives $10 off now. Do they have a $10 or less burger? That's the question. Hold the groin muscle kicking. What are the hazards of being on the dance team there? Yeah. Alrighty. It's your birthday. Go shorty. All right. No, not that one. We're not singing that version. Tammy Dunlap has the pancakes hot and ready with butter, and it looks like pure Canadian maple syrup as well. I think we got drum solo here. Everybody, drum solo, big finish. Beautiful. I do wonder if we have practiced the drums enough that any one of us could actually sit down at a real drum set and play that exact drum solo finish flawlessly. Our first attempt. It's been almost like what is it, Groundhog Day, where the guy learns the piano, and so it's not his first. It's always his first lesson. But we've had so much practice that our first day, the real drum set, we'd just be like, "Whoa, they're a pro."
Happy birthday!
They're a pro.
You look good.
Let's do it. Let's all go to music shops and film ourselves doing that solo on a drum set. It would be great. I think it would be wonderful. All right. Happy birthday to all those who are celebrating. It is Friday. It's No Pants Friday. We had a verdict yesterday. You first.
Fight.
I'll film it first, but I'm going to show yours before I show mine. Does that count? All right. I've got to film. I've got something else I have to film today, and I just remembered this morning that I have to film it today because there's a deadline on it. Okay, so we need some time. All right, it's too cold for No Pants. That my heater's on. You might be able to hear it in the background. Doing a little whistle. It does. That's because you have old vents that are clogged and they whistle. Sent you a text from a good hearing from yesterday. Did you get it? Did I get it? Probably. Did I read it? Okay. Josh, did you send it in mod chat? Newbunk Foss, TJIF, I hope everyone has a fantastic weekend. I hope you do as well. We have 2 full drum kits set up in our basement. I don't need to play the air drums. Red, why am I teaching the class when you were the pro? I feel foolish now. Crystal Ray says, good morning, all you fabulous, amazing addicts. Happy birthday to the birthdayers. Hope you all have an amazing day. You and Mrs. RA too. I hope we do as well. I'm hoping she goes to the store and gets me milk, like 8 gallons. If you were on the podcast last night, we talked a little bit about that. But a little bit of milk would be great here because we're out, and we couldn't go yesterday because the road was frozen. Yes, the road was frozen. It was funny because when people were driving by, like the people that have the studded snow tires, which we don't, it was just like, it sounded like something was being crushed. Like a car crusher was slowly just demolishing a building or something. And that was the sounds the road was making when people drove on it. It was so weird. Ice everywhere. Okay. I think she needs 10 gallons of milk. I would be okay with 8 gallons of regular milk and 2 gallons of chocolate. That would be my compromise. Josh, thank you very much. Put it in mod chat right now. Let me see if I can show this one. Oh, I like this guy. I like this one. Let me pull this one up really quickly. As Josh, is it the entire thing? Just looking, it's an hour and 26. Do you have a start time? A rough start time.
King. People do not get to have it their way.
Where'd my mic go? There it is. All right. Here it is. Oh, the start time was in there. I literally already had the message when I asked it for the start time. Josh, you're amazing. And I'm sorry I didn't read the whole thing. Let me get to start at 21:34. We are court hopping, so we don't have a new trial today, but we'll have one here very, very shortly, I think on Monday. Okay, 20:34. Seconds for the defendant being Greg Santa. It was Santa Claus? Traffic ticket involving a motorcycle. Here we go. We're going to do this one. I'm going to start with a tiny bit of backup. Make sure I get to the right spot. There we go. All right.
Dello Santa.
You're charged with failure to pay $357. That is the charge. If you plead guilty, if you're found guilty, you could be incarcerated for, in this case, it looks like, well, this is not a probation case, but I would still honor it for 5 days. Do you understand that?
Yes. May I add something?
Not yet. You're presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to a hearing, right to question their witnesses, right to bring in your own, right to use the subpoena powers of the court to bring in those witnesses if you plead guilty. You'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
You have the right to a lawyer. If you want one, we'll give you one. Do you want a lawyer?
No.
To the charge you failed to pay is set forth in the show cause, $357. How do you plead? Guilty or not guilty, sir?
Guilty.
Did you fail to pay?
Guilty.
Are you listening to my questions, or
No, I
can you
am.
not hear me?
I am listening. I am listening.
Did you pay the $350? Did you fail to pay the $357 that's owed?
Yes, because of unemployment.
Well, did you come and talk to the judge? She told you to pay $100 a month starting November 1. This is February. It doesn't look like you paid a nickel. Did you come in and seek permission? Say, hey, Judge, I don't have the money. I got laid off. I'm on unemployment. I can't eat. I can't feed my family. I can't heat my house. Will you give me an extension? When did you come in and talk to her about that?
Your Honor, I did come to the court and I paid money, and they didn't offer me a suggestion to make a court date.
Well, it's not a big formal proceeding. You just call the court or come in on her before your due date. When did he make a payment, Lisa? I don't see one reflected on. Oh, he made $10 in December 27th. Is that right?
Yeah, there's also a note in there that he was advised of open court hours for a new payment arrangement.
So you can't just ignore courts.
I
don't get this. This part of my job, I do not understand.
I wasn't even guilty of being stopped to pull over. He didn't see my brake light. I stopped with my clutch on my motorcycle, and I got a ticket for not stopping. I was already stopped.
Hang on.
Uh-oh.
This wasn't my case, but I know Judge Hessen, and I know she wouldn't have taken a plea of guilt or written this down if you didn't plead guilty. They gave you a 0-point violation, allowing an unlicensed driver to drive. The 2-point suspend charge was dismissed. I'm not going to go back and relitigate that. That's over. It's like the Lions trying to go back and say, hey, we want to play that game against Washington over.
That's fine. I'm not going to compare this courtroom to a sport game. Thank you. I'll pay my dues. Okay.
I just did, but don't start telling me about something that happened during the plea arrangement that you don't agree with now. And don't start getting smart with me. Do you have this to pay or not?
I'm not smart. I am smart.
Just
and I'm
tell
not
me if you
smart.
have this to pay. Just tell me if you have this to pay.
I don't have money. I'm trying to go back to work, and I'll give money from my unemployment, but I can't pay $100 a month, Your Honor.
You needed to come and talk to her.
Okay.
That's what you needed to do. In fact, the judicial clerk just told me that you were made aware of the open hours. You cannot ignore this.
Open hours. I believe they told.
You can come and see the judge. We're not, you wouldn't walk into a doctor's office at 5 at night and say, hey, I want to be treated without an appointment. You can come, listen to me. Listen. No.
You're yelling.
Listen to me. Hey, listen.
Trying to listen.
That's because you're accepting no responsibility. And now you want to go back and relitigate the case. And I'm not going to go back and relitigate the case. It's over. You pled guilty. She took your plea. She sentenced you. It's over. Now, if you need time to pay, you can give me a reasonable amount that you can afford to pay. But you can't ignore courts and then come in and try to relitigate the case 4 months later.
I didn't.
How much can you afford to pay weekly or bi-weekly or monthly? And so far, we're not doing good because you only paid $10 in 4 months.
I don't have the receipts with me, but I paid after Christmas or before and paid in January. I can afford approximately $25 a month on the unemployment I'm getting.
Where were you working at, sir?
I was working for Roush Industries.
Did you got laid off?
Yes.
Lisa, when I don't see anything else on this file other than the fact that he paid $10 on December 27th. Were there other payments made?
No, I only see one payment on December 20th.
I
So
came down and paid money in 2025.
Okay. On this case,
Yes, sir.
do you have the receipt?
Yes, I do.
Well, why don't you put it up to the camera? Because you know what? I've been here a long time. I've never had one person. Are you positive about that? Or the JIS doesn't reflect the payment made in January, Lisa?
I only see one in December, Judge, December 27th. I'm looking to see if he has other cases maybe he paid on.
Nope. I came down there.
Okay, so listen, we don't need to talk about this. I'm going to be patient. I'm going to wait, but I'm going to tell you this. I've been told this before, and in 30 years and 1.5 months, I've not had anybody tell me that they have a receipt and provide the receipt that indicates a payment was made when our records reflect no payment made. Not one. So you'll be the first one. You'll be the first one. So tell me what day you paid it. You have your receipt, you said there, right? Pull it up and tell me what date that was.
I'm looking in my folder for this.
I can't wait to hear.
Yeah.
Tell you what, you take your time. I don't want to rush you.
I want to, I looked in my folder.
Hang on. You take all the time you need to look because I don't want you to make any mistakes, okay? I want to make sure that today's going to be the day of my career when somebody's going to walk in here with a receipt when they told me they paid something and our records reflect otherwise. And if you can produce that receipt, barring something that's terrible, I'm going to waive the rest of the fines and costs for you, sir. That's how confident I am. Now, I could be wrong. There's a first for anything, right? When nobody was on the moon till the early 60s. So you keep looking, take your time. I don't want you to make any mistakes.
That's a deal.
Is this Aaron Glenn Williams here? Lisa, do we have him out there anywhere?
Yeah, he's coming in right now.
If you can produce a receipt, I'll waive the rest of the fines. He might have, if he could pay $10 more that he paid towards a $300 fine.
Where's he live? In Trenton? Brownstown? Does Judge Hessen let them appear on Zoom for these kinds of things?
Yes, she does.
He owes $22,000. That's what it's saying here. Is that true? Balance $22,000. I'm not doing this by Zoom.
Judge, she does have an afternoon docket if you want to have him come in around noon.
Yeah. Your name, sir? Mr. Williams, this is 15B756098. Your name?
You're muted.
You have to unmute and state your name, Mr. Williams.
Aaron Mullen.
You said AA Ron?
Can you hear me?
Yeah. I'm going to reset this for this afternoon.
Okay.
At what time, Lisa? 1, did you say?
Yeah, 1 o'clock is fine.
So I guess she's going to let you appear by Zoom. That'll be 1 o'clock in the afternoon. Our records reveal you owe $22,000 and some odd cents. So I don't know. You could address it with her. Okay,
that's with Judge Hessen, correct?
Correct.
Okay. And you said 1 o'clock?
Thank you. Yes.
Okay. Thank you very much. Have a great day.
Thanks.
Bye.
What is that thing on the wall?
This is People Against Loudermilk.
Santa's
Cassandra
way.
Jo Loudermilk,
Santa's
124R513611. Says defendant was here but left.
She was here, Your Honor. I told her to go talk to the Rockwood prosecutor, and she just disappeared.
How do you owe $22,000?
I'll just make a note, Lisa. See stipulation, defendant disappeared, reschedule. You find that yet, Mr. Dalla Santa?
Hang on, he's still using Photoshop.
Did you find that, sir?
I have been looking, and
I'll tell you what. Why don't you find it, and you can come talk to Judge Hessen this afternoon. How's that? Gregory
Okay.
Lawrence, Dallas Santa, 24W8362928. Unless you find it now, I told you I'd waive the fines. She's not bound by that. So you find that now, and I'll waive the fines. You won't pay anything, even if that's for $5. I will waive the balance. You got it. So I'll tell you what I'm going to do. I'm going to let you sit there and take a look at this. I want to be completely fair and make sure that you only pay 13 cents on the $100 owed, and I'm going to let you find that, and then everybody will be happy. We can close the case, and you won't have to pay fines. I'll tell you what. I'll be back here at 10:45. Thank you.
okay, thank you.
Greg, you need to get that Photoshop skill perfected in the next little while. We can fast forward. I don't know when 10:45 is. Let's see. I wonder if he just hangs up. It's just like, I give up. Okay, let me fast forward a bit and see if we can. Oh, that was my mouse, the new one. Oh, I forgot the new one has a built-in battery, so it doesn't break every time I drop it. That's better. Yay. Okay, here we go. Let's fast forward a little bit so we can see when the judge comes back. Oh, there's Greg. Let's see Greg. See if he brings everything. Look at that chair, though. Would you look at the judge's chair for a minute? Tufted back, studded, overstuffed. That is a nice chair. It's really nice. So under warranty, Greeners, I think it's an $8 mouse. I think I pay $8 for these. See, I've got two. I've got this one, and you see the little flashy light. And then I've got this one. You see the little flashy light. This one, they look the same, right? I mean, they look like the same mouse. This one has a battery cover right down here, and it takes 2 AA batteries. This one has no battery cover, and it has a USB-C plug on the front, which the other one does not have. So this one I can just recharge. But it's funny because it's the third time I've ordered this on Amazon because I break them. And I ordered I went to the old order and said, order another, expecting a battery one, and it arrived at USB-C. So it's like a free upgrade. Yes, this is in Michigan. I think that's because we know that because Greg's got the wood cut out of Michigan on the wall, and I think that's the Michigan state seal, and maybe the Michigan flag. Isn't that it? It's always Michigan. Reminds me of a Chesterfield chair. It takes a lot of nerve to have missed court and not complied with court orders and walk in and tell the judge, you watch your tone with me, boy. That's Greg's got a little bit of nerve there. Is that a Spyderco shirt that he's wearing? Like a fishing shirt? For those of you who it's a Black Widow spider, but is that the Spyderco logo? They make fishing line. Really, I'd say it's high-end fishing line, usually braided for catching large fish. Yes, it is. Haha. See, I haven't lost my touch. It's been years since I've been fishing, but I remember the products. Oh, Greg, please unmute. Please unmute. Shape on wall is lower state of Michigan. Helena, you found a new word I have to put in the banned list. I didn't even know that was a word. I've always seen it with an L, but I guess it can be read this way as well. Happy Friday. Oh, man. Add one to the banned list. Oh, my goodness. The flag says spice. Community settings. Blocked words. I can scroll through. Let me show you while this is going on. Let me show you the blocked words. See right here? This is my list of blocked words. I know you can't read them, but there are a lot. And I get down to the bottom, and right down here at the bottom it says 26. Show 26 more. And I'm going to add this new one that Helena Handbasket came up with. So now it says show 27 more. There we go. You can't say that word anymore on the channel. Helena Handbasket, you got your very own blocked word, and I think it's hilarious. Greener said, how many did I contribute? Probably a few. Let's see. Is this live now, the hearing we're showing? Laura, this actually happened yesterday. Happened yesterday while we were doing the verdict in the other trial. I'm praying he has it. I'm rooting for the underdog as well. I'd love it. I mean, if catching the court making a mistake, it's rare, right? It's happened, though. We've seen it in Judge Simpson's court when somebody had the proof and the court had the documents wrong. It could happen. I'd love to see Greg, especially because he's unemployed, and I wouldn't wish that on anybody. I've been there. I know how terrible that is. I'd love to see him just get the court fees waived. I'd hate it because he's been a little bit of a rude customer. I don't know. I don't want to use a bad word now that I put one of Helena's words on the banned list, but he's been a little rude to the judge, and you don't want to see the rude guy win. But at the same time, I'd love to see him get this fine thrown out. Yo Mama, a member for 22 months. One of our OGs says, wouldn't be anywhere else so close to a new color courthouse. You can almost taste it, right? Now I'm curious what happens if you say one, says Becca. Unfortunately, nothing. He's probably making a payment right now. Can you backdate that receipt for me? My plans for the weekend might include bathroom remodel because the replacement shower insert, the floor shower insert, should arrive possibly today. It's at the distribution point right now. So if it gets here, that would be great. Josh, I'm going to fast forward because now Greg's gone and the judge is gone. So let's see if we can. Oh, there he comes back right here. Okay, give us 10 or 20 seconds of empty chair, just for the. Man, that you can tell that leather is soft too. Do you see that? That's not going to be like the rigid, barely tanned, thick cowhide. That is supple. That's pliable. That's inviting. That chair is really, really nice. There's Greeners testing the limits of the filter. Domino's Pizza. Can
I see it?
You're at Domino's right now? Domino's for breakfast?
These will be in the menu now.
John Link, thank you very much. 20 months, another OG.
What's he here on?
He's handling Bivens and Kohler.
Is Kobler here? Colbert here? Recalling, go back on record. Mr. Dalla Santa, you can step up to the
phone.
People against Gregory Lawrence Dalla Santa, 24W836-292A.
Good morning. I'm here. You're on.
Your name?
Gregory Dalla Santa.
All right. Where is it? You got it? I want to waive all these fines for you.
I really understand your position, but I can't believe that would actually be true, even though I do not have a receipt. I did not pay, and I'm sorry. I thought I did. I went there with money.
No, that's what we do here, because we're honest about things here. And if you came out with I just told the staff down the hall, he comes out with a receipt that says he paid $5 after January 1, I'd waive all the fines. That's just the way we are here. We don't make mistakes like that. Okay. You understand what I'm saying? This is a court building. It's a courthouse. So you are either guessing or lying, and I don't appreciate it.
Well, I did come there with money, and my money wasn't given.
I don't want to argue with you. I'd give up my house for a cup of coffee if you could have come up with that. So please don't come in here and tell me you paid in January when we know that you haven't paid in January, because that would be what we call a lie.
I didn't mean it that way.
Word. Hang on. You insisted you paid in January. You've been painful to deal with this whole time. I'm going to cut this short. I'm not going to let you pay just $25 a month. We're not a bank here. You've owed this money for 4 months. You didn't come in and talk to Judge Hessen. You didn't come in and say, hey, can I have an extension? None of that went on. So you're going to have to figure out a way. I don't know where you're going to work or when Roush is going to call you back, if they're going to call you back. But I mean, we're not a bank. You don't get 16 months to pay $295 in fines and costs. You paid $10, and now you owe $357 after the $10 payment because of default and warrant fees and late fees and everything else. And I'm not going to let you pay $25 a month. That would take you, what, 12? That would take you 14 months to pay this, over 14 months.
That's less than 16. Can I make a statement?
Hang on.
Be careful.
What do you mean it's less than 16? Why, did I say 16? I might have said 16. Is that what you want to do, is criticize me? I'll deal with my math skills like against you or anybody else, but don't.
I'm not criticizing you.
I don't. Yeah, you're a wise guy. You're one of those guys. You're one of those guys that thinks you can talk your way out of things. I've seen it before. I see it every day, actually. So you're not alone. I don't want you to think. In fact, I don't even want to talk about this anymore. Yes, you're going to have to come up with a way to pay more than $25 a month. So I'll kind of work with you and let you deal with I'll let you kind of set up your own plan, but it's not going to be $25 a month. We're not a bank. So what are you going to do?
Well, I'm barely making it. I know I'll be back to work. I don't know when. I wasn't working with Roush at this time last year. I came back around Easter. So all I'm asking is you accept less than 50 so I have something to live on. That's all I'm asking. And
all I can tell you is October 23rd, you must have told Judge Hessen that you could pay $100 a month. She started it 8 days later. So, but you know what? Let's forego that. I'm going to let you pay $50 per week, and I'm going to start this on
per week.
April the 25th. And you'll be back to work by then. And if you're not back to work by then, you need to come into the courthouse at 8:30 in the morning and speak to me about an extension. Do you understand?
Yeah,
Yes, Your Honor.
That is fair.
Okay. I wish you well. Good luck. Have a good day. Thank you.
You too.
Are we ready on Kohler?
I think that was a more fair, generous.
Lisa, do I have the victim out here? I got a letter. I
outcome than
didn't.
he deserved.
No, not on Zoom. The letter was sent by email this morning.
Yeah, he's looking for it.
Where's the file? I need the file and I need the lawyer.
Oh, you got Kohler too. Okay, I'll let him know. Yeah.
Does he have a Kohler?
He said he's wrapping everything up. He needs 2 minutes.
But he has this Kohler?
Yes, sir.
Yeah.
Okay. Hang on one second. We've got to bail. We've got another one that we're going to return to. Josh, thank you for this. We're not leaving the state of Michigan. We're going back to... hang on one second. Let's turn this off. Back. To see when it started. Josh, do you know how long ago this started? I can see... Don't think it involves the Zoom people. There we go. I think it's right here.
Okay. And so you've chosen to waive your right to an attorney and represent yourself in this hearing that we've just had, correct?
Yes.
Okay. Okay.
Thank you, Your Honor.
We'll sign it up, have receipt. Thank you. Good luck to you both.
Thank you, Your Honor.
Okay. I think this is it. This is the swingers. This is the swingers.
So, good morning, council. I apologize for that. That took a little bit longer than expected. All right, and so the court is going on the record in the matter of William Branson versus Heather Collins, 2402269, and appearance for Mr. Branson.
Good morning, Your Honor. Amy P. 0461 on behalf of Mr. Branson.
Okay, I'm sorry, what would you say your name was, counsel?
Amy Ducre.
Ducre, okay, I didn't hear the last name, I just heard Amy, okay. All right, and
Good morning,
I
Judge.
did receive your appearance as co-counsel. And I'm sorry, counsel, your appearance.
Okay. Good morning, Judge. Ali Bedro, appearing also on behalf of Mr. Branson. Your Honor, I asked Ms. Ducre to come in because before she became a lawyer, she was a elementary school teacher and has got a lot of experience with.
Okay, hold on,
handling
hold on, we'll get to that in just a moment. Right now, I'm just putting everything on the record.
Yes, ma'am.
All right, and Mr. Branson,
Good morning, Your Honor.
your name for the record, please.
William Branson.
Okay, good morning. Okay, and counsel?
Good morning, Your Honor. This is Megan Dalpala. I appear on behalf of the defendant, Heather Collins, today.
Okay, thank you. Good morning, and your name, please, ma'am, for the record.
Heather Collins.
Okay, thank you. Okay, so today is the adjourned date for the parties to return. The issues that are, there's a couple things that we are hoping to resolve today. One is the escrowed monies. The other are utilities. And then there are some allegations as well regarding mail as well. The defendant had filed a motion to dismiss. Ms. Collins did improper prior to Ms. Declala submitting her appearance. And let's handle the issue of well, we're also going to address the issue of the
Is Dager Law out in
order
outside?
regarding the inspection.
Like the sun is.
I reviewed the order. I'm not going to sign it as written because this court did not order paragraph 2 that was added into the order. This court, I mean, obviously if there's a violation of an order, there's recourse. But I'm not, I didn't state in there regarding any interference or third party, so I'm not signing that order as submitted. So that would have to be removed before the court signs it.
Your Honor, can we do that now and resubmit it to you?
What?
We'll do it now and resubmit it to you. Ashley's listening, she's the one that's going to be.
Okay, that's fine. I'm just saying that, I mean, that's probably can be submitted. I'm just not signing it as currently submitted. The court is also going to address the issue of the I don't want to call it an inspection, but I don't know what I want to call it. Well, Mr. Branson's ability to look at the property as far as what maybe needed to be done or whatnot. So that was on the 10th, so we'll address that as well. Okay, so there is an allegation that Mr. Branson cannot proceed because he does not have a valid CFO. Ms. Collins, in her motion, references a specific paragraph that would not allow Mr. Branson to continue. Now, item 7 on the complaint states the plaintiff declares that this residential property was kept fit for the use intended, has been kept in reasonable repair during the term of the lease or license, and is in compliance with the applicable state and local health and safety laws. Okay. Any defects in the statement must be explained below. And then it says the disrepair or violation was caused by the tenant's willful or irresponsible conduct or lack of control. So counsel, I understand that your client filed this, but you also did indicate at the last hearing on Tuesday that you were relying upon the motion. And so what part of that would require this court to dismiss this action?
Your Honor, this action must be dismissed under MCL 125.530. That is the Michigan law that requires a certificate of compliance to be held by a landlord. Under paragraph 5, it states that an action may be maintained where there is not payment into an escrow account. So,
sorry, what was that? An action what?
May be maintained, an action to recover possession of the premises may be maintained where there is not payment into an escrow account.
Maybe.
My client has been paying into the court's escrow. I have the register of actions here.
I understand. Yes, this court had signed an order of escrow.
Correct, and she is in complete compliance with that. On January 21st, she paid $4,000 into the escrow account as ordered. On January 31st, she paid her monthly rental amount in the amount of $1,500. Of course.
Sorry, just one moment.
Sure.
So you're relying on MCL 125.530, paragraph 3, which you said paragraph 5.
I did say paragraph 5. I'm actually relying on the entire, all the provisions of 125.530.
Okay, so just for a moment, please.
Yeah.
So council, you have 125.530 pulled up?
Yeah, yes, Your Honor.
Okay. Okay, so I believe that 125.530 would speak specifically to the issue as to where the monies go from the escrow account.
Your Honor, if I may.
Just one moment, please.
Sure.
Right now, I'm addressing the motion to dismiss portion of it, not the portion that we're going to address regarding the payment of the escrow account. So as to the motion to dismiss, Ms. DeClala, what in paragraph 7 would support the request to dismiss this action?
Okay. So I'm referencing 125.530 generally. This was brought up in the defensive responsive pleading and it was relied on quite heavily. It's actually stating that the property can't be legally rented out when it doesn't have a certificate of compliance. You know, that's pretty obvious to us. The issue here is whether an action in eviction can be maintained a summary proceedings in local district court where there is not a valid certificate of compliance. There's certainly not a valid certificate of compliance in this case. We're all aware of that. There's an inspection scheduled with the city in order to correct for that. In particular, I'd like to draw your attention to the court rule for these proceedings. In particular, I'm referencing MCR 4.201 B3C.
Okay, let the court find that one.
Okay, let me pull that up.
Again, that's MCR 4.201 B3C.
Who's the clicker? Who has the pen? Is that the far table?
I'll go ahead and read it.
Just a moment.
Sure.
Complaint specific requirements. 3C. If the tenancy is of residential premises, the complaint must allege that the lessor or licensor has performed his or her covenants to keep the premises fit for the use intended, in reasonable repair during the term of the lease or license, and in compliance with applicable state and local health and safety laws, except when the disrepair or violation has been caused by the tenant's willful or irresponsible conduct or lack of conduct, or the parties to the lease or license have modified those obligations as provided for by statute. Plaintiff must explain any defects in this allegation, for example, local government's failure to inspect despite a request to do so. The relevant scale form must provide space for this explanation. The court may not refuse a filing based on anything in this sub-rule. Okay?
Okay.
So you're relying on the part stating that the plaintiff is not in compliance with applicable state and local health and safety laws?
Correct. And
okay, so what local health and safety laws are not in compliance?
Okay, that would be the City of Wyandott's Ordinance 181.020. No, 181.020.
Okay.
No person shall lease, rent, or cause to be occupied a rental dwelling or rental unit unless there's a valid certificate of compliance.
Okay. So does that fall under
I'll be down
state and local health and safety law?
Yes, it does.
Okay. How does that fall under there? Because that seems to me to be an ordinance that the city can then enforce against Mr. Branson.
Absolutely, Your Honor. But you know, that's exactly to my point. It's something that the city can enforce, and this is meant to protect the safety of its citizens who are renting out residential units. So it's in direct conflict with the court rule that requires when you file a complaint in these matters for the landlord to represent that the residential property is being kept fit for the intended use.
Okay, so what's in direct conflict, counsel?
Okay, what's in direct conflict is that the certificate of compliance is required to assure the health and safety of the citizen living in the unit. So in order to file a complaint and represent that it was kept fit for residential use, not only is it required under local law for the City of Wyandotte under section 181.02, But also, under the court rule for filing these actions, the complaint must allege that the premises is kept fit for the intended use and it's in reasonable repair. So, as you mentioned, then it goes on to state in compliance with applicable state and local health and safety laws. Certainly, 181.020 is a local ordinance that's protecting the safety and health of its citizens. That is a local ordinance that's meant to do that.
Okay, and your response, counsel?
Your Honor, my response is severalfold. First of all, the applicable MCR 4.201 sub B, sub 3, sub C clearly states in its express language that that this matter cannot be dismissed for a defect of this section. It says that, it's the last line in here. The court shall not refuse this pleading because this is not complied with. So even if there is a defect in the way that he pled this pleading, that doesn't mean that it should be denied.
Okay, it reads a court may not refuse a filing based on anything in the sub-rule. So the court has to accept the filing. Okay, so the fact the court has to accept the filing doesn't mean that it cannot be used as a basis to dismiss the matter.
That's the loudest mouse ever.
Yes. So that defect is not a fatal defect as sister counsel claims on the face of the pleadings. That's my argument, Your Honor. Second of all,
I'm sorry. So the defect that your client does not have a certificate of compliance or certificate of occupancy, whichever the title is. I think that it was changed at some point. And so you're stating that that is not a violation of the third part being in compliance with the applicable state and local laws?
It's not a local health and safety law, Your Honor.
Okay.
This is a municipal code under the building code. And if you read section 181.001, where it talks about the certificate of compliance and the purpose of it, a certificate of compliance is issued by the Department of Engineering and Building, which certifies compliance with provisions of codes and ordinances of the city for all rental and dwelling units. There's no mention anywhere in the statute that this should be applied as a health and safety standard. And without actual case law or some citation or some legislative and quasi-legislative intent of the body who enacted this, it doesn't fall within the health and safety laws of this city or the state of Michigan. Moreover, there is a direct statute on point, Your Honor. And that direct statute is the statute that Ms. Aflalo was talking about first. And if we go provision by provision through this statute, Your Honor, you can see that their argument is completely erroneous with the plain language of the statute. And we're talking about section 1.25.530. And if you talk about subsection 5, for instance, it is clear that it says when the certificate of compliance has been suspended or has not been issued and the rentals thereafter withheld are not paid into an escrow account, meaning Ms. Aflalo and defendant are looking at the wrong time period. The defendant did not put monies into an escrow account until she got involved with this court proceeding. She had provided zero evidence or zero proof that there was any escrow account. Moreover, if you continue to read that provision, Your Honor, it says that the escrow account must be managed by the authority with the department with the authority to oversee compliance with the certificate of occupancy, meaning that the defendant would have had to place, at the time she withheld those rents, at the time she decided, I'm going to withhold the rents because you don't have a certificate of compliance, she would have had to place those monies in escrow with the building department of the city of Wyandotte. And she didn't do that. So she's not in compliance with this statute. And when at the time that this provision was filed, so her complaint now that there's a defect on the pleading, that it falls outside the scope of the court rule and that it falls outside the scope of this provision is erroneous, because even if you look specifically at the other provision that Ms. Aflalo stated, which is 1.25530 subsection 3, it says that the duty to pay rent is suspended, but the monies have to be paid into an escrow account. So defendant comes in here with unclean hands, Your Honor. She comes in here having withheld rent, and the first time she made a complaint is after these proceedings of eviction have started, and it was only after the order of this court that she put her monies in escrow. She cannot now come into this court with unclean hands and try to fix what she did wrong because this court ordered her to do something that she should have done from the beginning. Plaintiff is within his right to bring this action.
I've zoomed in on the guy who's doing the clicking.
May I respond?
Just a moment.
I'm going to keep the court audio going, but I'm going to show you him without the sound. Well, there we go. This is him clicking. I don't know if this is Instagram or Tinder or.
So as it relates to not
doing.
having a certificate of compliance,
He's clicking through and watching
city,
something.
I don't find that the remedy for that is to dismiss this action. So on that point, I'm going to deny the motion. You also allege the property was not kept for tenants' peace and enjoyment required by law. And then also that it was not kept fit for the use intended. And never did finish the kitchen update. So I can't rule on that without taking testimony regarding the intended, whether or not it's been kept fit for the use intended. And whether or not it was kept for your client's peace and enjoyment. So I can't rule on that portion of the motion until I take testimony on those matters.
Okay, I'm guilty of this one.
So,
He's looking for a new mouse. One with a quieter clicker. So the other party, the gentleman who I think is the owner of the property, he got a new lawyer for this hearing, and he was trying to tell the judge, I got this lawyer, and I'm going to put some words in his mouth because this is where I think he was going. He said, I got this lawyer because she used to be an elementary school teacher. She's good to explain things to children.
Now,
I think that's what he was going to say. Don't quote me.
counsel, your client has stated that the property was not kept fit for the use intended. For example, a bug problem. Okay, so I'm going to swear in Ms. Collins and Mr. Branson. If you can both please rise and raise your hand. Do you both solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Yes, Your Honor.
All right, thank you. So Ms. Collins, or counsel, Ms. Iqbala, your clients raised the issue that the property was not kept fit for its intended use. Okay? She cites, for example, a bug problem. I'm not sure if there was any other problems. Okay, not finishing the kitchen. So other than those two issues, are there any other matters that your client is alleging where the property is not kept fit for its intended use?
May I allow her to speak on it?
Well, first I'm asking you, counsel.
Okay. There's a mold issue in the basement causing significant health issues.
Okay, hold on just one moment. All right, so you're alleging it's causing significant health issues.
Your Honor, my client is asking if she can sit down. She's not feeling well.
Okay.
Thank you.
Must be the mold.
All right, so let's talk about this. All right, so you're alleging a mold issue in the basement causing significant health issues, a bug problem. The kitchen was not finished.
There is a window in the basement that is almost fully detached from the front wall, allowing, a lot of environmental issues like wind, water, rain.
Hold on, let's see. Window and basement, almost fully detached from the wall.
Yes.
Okay. Okay, what else?
I would like her to continue if it's okay.
Well, counsel, I'm asking you because you're representing her, so I'm asking you right now. So what else?
The basement floods. Separate from the window issue.
It floods from two sides.
There are certain fixtures within the house, such as vents, that are completely detached from the wall.
Okay, I'm sorry. Fixtures
Yes.
detached from the wall.
Yes.
And you said such as vents. Anything else or only vents?
There are filters that are broken.
Council, I'm still on the fixtures attached from the wall. Is it only vents? Is there something else that is attached from the wall?
I'm not sure.
Okay. Ms. Collins, yes or no? Is there anything in addition to vents that are detached from the wall?
There is.
No, yes or no?
Yes.
Okay. What else is detached from the wall?
There is, off the flooring, off the back rail of the steps, there's a metal plate that comes right off. You can just pick it up and fall right through.
Is that the wall or the floor?
The floor, excuse me.
Okay, so I asked about the wall.
The vents, all the vents.
Is there anything other than the vents that you're alleging are detached from the wall?
No.
Okay. All right. Mr. Clowney, you may continue.
The windows in the basement.
That's already been addressed.
I suppose there may be more than one window with maintenance issues. There is one main window that is almost completely detached from the front.
Okay.
The vents don't close?
Some don't. One room has no heat or air.
Okay.
There's one room with no heat or air conditioning.
Which room is that?
My mother's room. The front.
I'm not sure.
It's my mother's room.
The lawyer wants the defendant to speak.
I don't know what that
It's
was.
the
The first
very-
floor, upstairs, where is it?
Upstairs, very front.
Katie Russell, you're going to have
Is
a
there only
great day today.
one room in the upstairs front?
Yes.
Okay.
Why would you close the vents?
I'm not sure that's an exhaustive list, but that's what I'm aware of.
Okay.
This one we've
Did
come back
you
to several
send
times.
any of
This
this
is a crazy.
communication over to Mr. Branson's attorney before today?
Oh,
There have been,
There's also more than just that, yes.
Hold on, ma'am.
there have been many exhibits filed, but the problem is that I have.
So that wasn't my question, counsel. My question is, did you specify these concerns, the ones that you just stated? I understand it may not be an exhaustive list. Did you specify these concerns with Mr. Branson's attorney? Yes or no?
I did not.
Okay, so counsel, let's, actually, Mr. Clow, what's the bug problem? Your client alleged in the motion a bug problem.
Yes, she's having to shower with swimsuits on. The bugs are so intense in her shower. I filed quite a bit of exhibits. Contained within those, there's text message evidence that she's asked her landlord several times to fix the bug issue.
Okay,
She's swimming in
which
bugs.
page of the exhibits are we referencing on that one?
Okay, one second. Your Honor, respectfully, I have a time limitation today. If we're gonna have a full evidentiary hearing, is there any chance to be able to prepare for that and come back, or no? There's a lot of exhibits.
This is your client's motion to dismiss, so.
Motion to dismiss, yes.
Right, but one of the
Okay.
elements of that is that your client claimed that it was not kept fit for habitability.
Okay.
So I'm trying to, I said I couldn't, make a ruling on that until I took testimony, so that's what I'm doing.
I don't have a specific page number, but these were filed, and that was on Tuesday. May I approach the bench with?
What was filed on Tuesday?
These are text messages.
On Tuesday those were filed?
Yes.
I think that, Let me, is there a date on those text messages?
Yes,
Okay, what's the date?
it's June, July, and August.
June, July, and August, okay.
Your Honor, it's the 102nd page of the document that you filed at 8:03 in the morning on Tuesday, just before the last hearing. Page 102, Your Honor.
Okay, I'm not sure if I have that.
There's no bait stamp on there, Your Honor, so that's the problem. That's part of the problem.
Well, let me see. So I'm showing, what I have here is January 31st, and our landlord tenant clerk has unfortunately been out ill. So it's page, okay, but I need to check to see if Carly can grab that off and
Carol, that was a gift someone printed for me because there was a bug incident on 10/27 of 23 in my studio. The date is written on the bug.
I'm not showing anything here.
Your Honor, it isn't actually, there is a bait stamp on it. There is
Supposed to be
a
a
document
cockroach.
that is, like we have it, it says that it was filed with the court on 2/18/2025. And if I could assist sister counsel, the text message is in that document. So if that's the document that you have, you might have the text message that she's speaking of, and it is on around the 100th page.
I have January 31st. I have a date stamp thing. I don't have that one. So if you, I'll take, let me just let me go off the record for a moment. Let me check these people in here, and then let me go jump off and grab that to be printed. Just one moment. In the meantime, Ms. Watson, we're gonna try to figure out who's here for Mr. Landau.
Okay, thank you.
Okay, Attorney Francis, good morning. Which matter are you here on?
Good morning. I am here for Portfolio Recovery 2400946. 2400946 GC, Portfolio Recovery.
Okay. Okay, just one moment. All right, good morning, Mr. Katz.
This is a separate issue, right?
And, all right, you're here on Mills, correct?
Yes.
Okay, Ms. Mills, good morning, or Ms. Tagger, I'm not sure which individual, but I will put the two of you into a breakout room. Let's break
Okay.
out. All right, and Bankstein,
Good morning, Your Honor.
good morning. Which matter are you here on?
I'm here on LVNV funding versus Nicholas Sarasuolo.
Okay. And what is that case number? 230?
02342-GC.
Okay. Okay.
Wilson, 10:30, Wilson, 10:30.
Oh. And then crime management, okay. That's it, I'm checking it out. All right, just one moment.
While she gets that paperwork sorted out, we're here because this is happening live, first of all, and this is a case where the defense or the attorney, this is right behind my picture right up here, right here, brings the drama in a big way. This has been a case where The judge has been accused of participating in swingers meetings. That's how they know that she knows the defendant. It's been triggered so badly they can't even be in the same room. They've required a third-party intermediary just to talk to each other. Every time don't go their way, it just blows up and the accusations start flying. So part one was spicy. We're past. I think the swingers accusation is behind us now. I think that we're safely not going to revisit that one. But the judge is like, I can assure you, no, that did not happen. But yeah, so that's why we're here. I realize this part might be a little slow and boring, but at any moment, this particular matter, this proceeding, has been known to just go off the rails and blow up, and we're here for that. So we're gonna see what happens. It sounds, I mean, this is a landlord-tenant dispute at its core. This is, at the end of the day, no one's going to jail for this. There will be a monetary judgment one way or the other, or just dismissed. But the tenant doesn't want to pay because she says the landlord has not been doing his part of the agreement. The landlord says, I've been doing my part of the agreement. She's not paying. And so the judge has to get in the middle and work this one out. We'll back up. This judge, yes, this judge. Part one, I think Law Talk with Mike has the whole thing. I think I'm a tiny bit behind. I don't know what that bailiff is clicking on. What in the world would he have that he has so many pictures to click through? And the formatting is all different. He's got to be on social media. I'm thinking Facebook. I think he's going through Facebook. He's clicking like crazy right now. It would be like click, 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 click. I don't think it's court documents. Right now they're both going to look. Which one's your favorite? Amber, thank you very much. There's another one that Weather Watch found for us. Thomas, by the way, great podcast last night. Thank you so much, my friend. If you missed it, you need to go back and watch. Okay. Oh, wow. That's way... I was scrolling through all her recent ones. We'll go back and watch that one next. We are taking a little bit of a lighthearted break, sort of palate cleanser between trials, as we just got off a very heavy trial. Facts of the case are pretty difficult, and it was honestly, it was quite divisive. So we're just remembering that we're all friends, even though we don't always agree on the same thing, and we'll be back to a new trial here in just a bit. Evangeline, thank you for being there on the live. It was fun. Was a fun podcast. Verdict days always are crazy busy, right? We usually pick up a lot more viewers on a verdict. People watch the channel that don't normally watch the channel on verdict days, and it sort of, crescendos in a trial like that. So at the end, chat can just get nuts. It just goes wild with lots of new voices, new people, and some of the comments are it's the hardest work for a mod as the closer we get to a verdict. It was crazy. Let me tell you, from a YouTube content creator perspective, it's a good day because more people watching the channel is better. But from a logistic standpoint, the mods, it's the bad time. So we're at odds here. To give you an idea, to get your channel recognized as a YouTube partner, so that you can do this for a living, so you can make money working on YouTube, there are certain thresholds you have to meet. And one of them said that I think in the last, if I remember correctly, it's in the last 365 days, you had to have, I think it's 4,000 or 5,000 watch hours. That's how many combined minutes from everybody who ever clicked on any video. watched, even if it was only for 10 seconds, they add up all those 10 seconds and the 10 minutes here and the hour there and the 2 hours there. They add up all the viewers' time and put it together. And they say in the last year, in order to become a YouTube partner, you need to have 5,000 watch hours. 4,000. Thank you, J2 Wells. Yesterday, we were over 32,000 watch hours just yesterday on the channel. Which, you know, I remember looking at those and thinking, how in the world do you get 5,000 watch hours? And yesterday hitting 32,000. We've been a YouTube partner for years now, but it's still no, it doesn't work out that way. It's not that good, but it's just amazing, and it just reminded me of how quickly this community grew and how fun it was to. At the beginning, when those watch hours, we hadn't met those watch hours. Now we did on the fourth day. We got over 5,000 or 4,000 watch hours. We got 5,000. We got over the $4,000 not dollar. That would be nice. 4,000 hour threshold on the fourth day we live streamed. But so it's fun. It's fun to see that. If I watch it 2 times speed, what does that kind of? I don't know. My wife watches it 3 times speed now that she's able. I don't know why she's able to do that on her account, but she can watch things 3 times speed. I'm going to fast forward until the judge comes back. They want the mouse again. I need a different place for the mouse. Okay, we are almost caught up to live. Just 1 second. Here we go. She's back.
Okay, so I have 105 pages on that. Miss Francis, your matter, there was an e-notice sent to you on February 18th that adjourned this to March 4th at 10:30 a.m. Did you receive that?
No, Your Honor, we did not.
Guessing not, since you logged in today. Apparently there was a conflict with the defendant court date. I don't know. I was just told that it was adjourned. There's e-notice sent to you, to both parties on Tuesday, and so it's moved to March 4th at 10:30 a.m.
March 4th at 10:30. Okay, thank you, Judge. I'll make a note of that.
Okay, you're welcome. All right, have a good day. Okay, Ms. Rossin, I don't know that anybody is going to be showing up on your matter. I don't know if Mr. Landau's office was given notice. As I stated, our landlord and tenant clerk's been out ill. And so what I'm going to do, and then we will, actually, I'll just let you know now, we're going to adjourn this to February 28th. So that's next Friday at 9:38. Okay.
Okay, February 28th at 9:30.
Yes.
Her mic's working.
Okay, and that's another Zoom, or is that in person?
That Zoom, unless you want to come in person, you're more than welcome to come in person.
Okay. Okay, thank you.
Okay, can we put Mr. Wilson out in the lobby? Can we put him in the room? Can you ask Mark to put him in the room, please?
Yeah.
Because the attorney's not there. I'm just going to check these individuals in and move them to breakout rooms. All right, good morning, counsel. Mr. Counsel Baig. Mr. Baig.
Good morning.
Good morning. All right, I'm going to put you into breakout room here. Mr. Wilson is present at the courthouse, so we're putting him in the room and then we'll put him in the breakout room with you, okay?
All right, breakout room then?
Yes. All right, you'll be there in just a couple moments. All right, and then.
I took her fishing on a date once, ice fishing.
Right.
We were there for about 10 minutes. That was the last time. It was the first time. It was also the last time. She's not a fan of ice fishing.
Good morning, Mr. Georgie.
Good morning.
Mr. Georgie.
How are you?
I'm fine, thank you. How are you?
Not too bad.
Okay. And then I see Attorney Ewing is also present. I'll put the two of you into a breakout room, or is there a resolution you're putting on the record? What are we doing?
Well, if we could do a breakout room, that would be appreciated.
Okay, that'll be breakout room 5.
Okay, thank you.
All right, thank you. And then Ms. Wilbur? Good morning.
The judge is herding
Good
cats.
morning, Ms. Jones. I'll put you and Ms. Jones in breakout room 4.
Thank you, Judge.
All right, then let's continue this hearing because the lawyers have been standing this whole time waiting to speak.
All right, so let's go back on the record in the matter of William Branson versus Heather Collins, 2402269. And all counsel are present, all parties are present. So the court did step off the bench to grab the
pictures.
The exhibit. Is this all exhibit 1?
No, it's exhibits 1 through 9.
Okay, so, and none of these pages are numbered?
Unfortunately, I did not have time, and I wanted to submit it before Tuesday's hearing.
Okay.
So you did
Your Honor, if I may.
So.
A halfway job.
We just have 2 objections to this.
Two objections to what?
These exhibits, Your Honor.
Okay.
The first objection is the documents were supposed to be turned over in this case by January 31st. And they, on the eve of the last court hearing, produced 105 pages of documents that are not marked. Second of all, if you look through the substantial number of these documents, they reference text messages, which are not the full record of the text message, and they bear no date or time as to when they are sent.
Okay, so let me take those one by one. One, the court's going to still allow the exhibits to be submitted because counsel filed her appearance and appeared in these matters after January 31st. So I'm going to give leave for these exhibits to be admitted. Just as though, and there's also been adjourned court dates as well. So as there are other matters that are brought to the attention and exhibits are continuing to be submitted to court, so it's kind of more of a fluid.
That's our plan right now.
As the text messages, the objection is noted. I'm going to see if I can voir dire some to try to figure out what it is or not. Where you're talking about the June, July, and August?
Yes, June, July, and August. It's exhibit 5 in terms of the bugs in particular.
Exhibit 5.
Please hold up the picture, Judge, so we can all see. I'm going to move in the corner so we can get a better chance to see.
Exhibit 5. So let's go to Exhibit 5. The first one I have is dated Sunday, July 14th at 10:57 a.m.
The first under exhibit 5 that I filed is from Friday, August 2nd.
August 2nd, why would it not start with July 14th?
They are in reverse order.
Okay, well, we're going to start with Sunday, July 14th, because I would presume that that's the way we need to start. So, the first one says, sorry to text so early, those bugs are back in the tub. I seen them yesterday sprayed what I have and they are still there today. These things don't want to die. What type of bugs are we talking about?
Your Honor, there is a page before that.
Please tell me it's a water bug like
okay,
this.
that shows August 2nd. I didn't realize that would be attached to Exhibit 5. I thought I missed that part. I thought it was only the title Exhibit 5. All right, well, I'm not going to review August 2nd until I'm at that date.
That's, so exhibit 5 is actually in reverse order. So the last page, it starts June 18th, and then the one where it says exhibit 5 is in August. It's the last communication. I do apologize to the organization.
Okay, well, the back of Exhibit 5 for me is September. I don't know, Is there an exhibit 6?
Yes.
Oh, there's exhibit 6, so maybe that's exhibit 6.
If the lawyer had spent maybe, I don't know, 5 minutes organizing these, that might have been better.
So, counsel, just for future reference, the exhibit page should not have any exhibits with it.
Okay.
So, okay. All right, so going backwards, Tuesday, June 18th.
Correct.
Count at 3:43 PM. Does everybody have that one?
Yes.
And, counsel, if you don't mind, if I just call your attorney Amy, that's a little bit easier to say.
I would prefer that, thank
Okay,
you.
thank you.
My last name is significantly difficult. It's very French for literally no reason at all.
Okay.
I'm trying to get to where you are because I think that when I was going through the exhibits, I may have shuffled them around. But now I think I located, you said Tuesday, June 18th at 3:43?
3:43.
Yes, you're right.
Yes, all right. Also, if you could look, and I'm presuming that the dark background with the light writing, the light writing is from Ms. Collins, correct? Okay. And then the white background with the dark writing is from Mr. Branson, correct?
Yes.
These are
Is that correct,
screenshots
counsel?
of text messages.
That's my understanding, Your Honor.
Okay. Okay, for Ms. Collins, also, if you could look at these little black spiders, I have all in the bathtub and the bathroom floor tomorrow. When you're here, I appreciate it. I tried to clean them out of the bathtub.
Little black spiders.
Mr. Branson's response. Oh, no. Okay, then there's not anything until Thursday, June 27th at 7:49 PM. Okay, was there any communication between the two of you regarding these bugs after June 18th?
Certainly. Yes, ma'am.
Okay, where are those?
I don't know, but we could certainly. Yeah.
Well, first, if you're asking this court to accept these exhibits, why am I getting partial conversations?
He asked me to take care of them myself.
Okay, that's not my question. Counsel, you've submitted these as exhibit. So this court can view the communication between the parties regarding the bugs. And these are an incomplete transcript, so to say, of the text messages.
I don't. He might have not actually responded.
You might just put your phone away unless the judge asks you.
Yeah, no phone in court, please.
Was there additional communication after June 18th and before June 27th regarding the bugs?
I can't recall.
Mr. Branson?
Yes, ma'am.
Okay. Do you have those on your phone?
My phone is in the vehicle because of the situation that's been going on with phones.
Okay, so that wasn't my question, sir.
Oh, I'm sorry. No.
Do you have them on your phone?
Yes, ma'am.
Your Honor, I'm sorry, I don't mean to interrupt you. I think our administrative assistant has them and she can put them on the screen for you if you'd like.
I object. I need to be able to review exhibits in advance.
You submitted it.
Well, counsel, you've offered the text messages between your client and Mr. Branson as a way for this court to determine whether or not there's an issue of habitability and the property was kept fit for living, and I have partial conversation here. So I need to have the full conversation. So this is new for everybody because, well, your client has everything printed up. Or do you have those printed up, ma'am?
I'm going to look at them here. Put them in this pile.
They took excerpts.
Your Honor, she has them and she did.
Counsel, we're not gonna have any communication right now until we see if these are in here.
I'm telling you, this thing heats up at a moment's notice. I don't know. Does anyone remember the dollar amount this is over? Is it like 6 months rent? Is it $1,500? I'm curious. Is it $22,000?
Judge, I'm just going to stand up because my back hurts. I apologize.
That's fine.
I said 2 months. Painful.
Okay, so we have one client who can't stand up, the other who can't sit down. Doing yoga stretches in the background. Downward dog. There we go. Yep. Roll that back. He's now stretching using the bar. Vader Poppins. Be a bingo. Escrow has 5,500. Okay, so it's significant. Over 9,000. It's a lot of money. Yeah, the lawyers. This communication is the problem.
Your Honor, I have more complete communications from earlier in July, the 13th and the 14th.
I'm looking for June, between June 18th
I'm sorry,
and
yes.
June 27th.
Okay. It's July as well. Just looking for between June 18th and June 27th.
They've spent. Oh, where'd the defendant go? He's just wandering out of the courtroom. he's taking a stroll through the gallery. I guess not the defendant. He's the. Is he the plaintiff? I don't know who raised this. Oh, he's back. He's back. All is good. Mr. Ewing here right next to me has a headache, and it's not even his turn. This lady has printed out everything, but there's no rhyme or reason. Sorry, I had to do those gulps for the judge. There's a rule in courts when you submit evidence that the other side can say, basically, you're taking that out of context, and in the rule of completeness, we need to see the whole picture. The judge called this one out. It wasn't an objection from the other side, but the judge called it out and said, I'm seeing one side of the conversation or a little snippet. Was there more? Yes, or I don't know. I think so. She says, I need to see it all. And then the person who wanted the little snippet to come in is saying, I object. I object to you seeing the whole conversation.
While you're looking for that, I'm going to handle a couple of matters, okay?
Oh, good. Mr. Ewing's like, please let it be me.
So let's see here. Mr. Katz?
Yes, Your Honor.
Oh, the lawyer's gone.
I'm going to handle your matter here in just 1 minute, in just one moment. Yeah, I'm going to handle a couple of ones while I'm looking for those.
Judge DeSanto is not going to make everybody else wait. Well, this one client cruises through a ream of screenshots.
All right, Mr. Wilson, can you please unmute Mr. Wilson, or Terry for Mr. Wilson? We're going to put him into breakout room 2.
Okay.
All right, and so we are on the record then in the matter of
I'm going to fast forward a little bit so we can get caught up because they're still looking for
breaches
pictures.
of partners for all right, and let me see, Mr. Georgie and Mr. Ewing.
She's still catching up on some other stuff.
Understand that Ms. Wilburn represents the interest of Epic Property Management and not your interest, correct?
Correct.
Okay, we're going to be live. We're live.
I think she took that to DHS. She has been approved, but not for the full amount. So I think that's probably where you were going with that.
Well, it was, right, because I showed that there was a resolution reached, but then the court was not entering the judgment because the court was going to do that document so Ms. Jones could submit it. Ma'am, how much were you approved for?
I'm sorry?
What was the amount of rental assistance that you were approved for?
$1,038.
Okay.
Okay, so we're waiting for
I'm
the.
just going to make that note on here, council.
Okay, here comes counsel with the client again. They might be ready. Possibly we'll go back to them as soon as this little proceeding.
So if you can indicate that in paragraph 10,
Judge is taken
council,
up.
that there
It's
was
done.
rental assistance approved. Ms. Wilbur?
Yep, Judge, I will indicate defendants have been approved for $1,038 through DHS.
Thank you very much. Okay, and so the court then does find by consent as to Ms. Jones, default as to Mr. Jones and Ms. Busha, as this matter was scheduled for 10:30 and it is now 10:58, and it's been determined by Ms. Jones that the individuals are not going to be appearing because they are at work. The court does find that plaintiff does have the right to recover possession of the property. The court also finds the waiver of rights is valid as it relates to Ms. Jones, and the terms of the judgment are reasonable. The court will also note that if defendants never brought on or before March 3rd, plaintiff can apply for an order evicting the defendants. Additional money may be owed if damage to the property occurs or rent continues to accrue. Partial payment will not prevent the court from issuing an order evicting the defendants. No money judgment will enter at this time, and the court will sign that upon receipt.
Thank you, Judge. I will follow that this morning.
All right, thank you.
Have a good weekend.
Thank you, you as well.
Thank you.
All right, thank you. Good luck to you, Ms. Jones.
Thank you.
Thank you. Okay, Mr. Mudar?
Yes, Your Honor.
Good morning.
Good morning.
Okay, so Ms. Rawson was on here. She's been on since about 9 a.m. and I didn't see anybody from your office here, so I adjourned it to next Friday at 9:30 a.m.
Thank you, Your Honor. I do sincerely apologize to you in the court as far as that discrepancy is concerned.
Okay, thank you. That's fine. Just next week, please make sure you have a shirt and tie on. Thank you.
Not a problem, Your Honor. What was the time on that? I do apologize.
9:30 a.m.
Thank you, Your Honor.
Make sure
All right,
you
thank
have a
you.
shirt
Have a
and
good
tie.
day.
You do just the same. Happy Friday to you.
Okay, thank you. Okay.
He threw a suit coat over his exercise outfit. Called
Okay, Mr. Ewing and Mr. George, there's not a resolution?
No, Your Honor.
Okay, well, we'll set this for an in-person trial.
That's fine, Your Honor.
We're on the record, the matter of Gordon Filson versus Daniel Martinez, Discount Dan Auto Repair 2302582, and some appearance for a plaintiff.
Gordon.
I'm sorry, Mr. Ewing, that didn't come through very well.
I apologize. Attorney Sean Ewing on behalf of plaintiff Gordon Filson.
Okay.
Good morning, Your Honor. John George, P27843, appearing on behalf of Dan Martinez plus Dan's LLC.
I like
thank
George.
you.
John George. Goes by Georgie.
And Mr. Martinez, would you like to place your name on the record, please?
Yeah, Daniel Martinez with Discount Dan Auto.
Okay. And
Discount
so,
Dan.
counsel, you've been here a couple of times. My notes show that discovery was started, not completed. It was to be completed by February 14th. We adjourned it to today's date at 10:30. Mediation was to be scheduled. When's your mediation date?
Mediation was done this past Wednesday, February 19th, and we did not reach a resolution at that mediation.
That is correct, Your Honor.
Okay. All right, I'm going to set this for an in-person final pretrial, whereby we'll determine the trial, we'll pick the trial dates, and we'll narrow down the issues. And the court will set that for March 14th. At 10:30 a.m.
May I check my schedule, Your Honor?
Okay.
Take your time, John. The judge is like Speedy Gonzalez. And John does not operate at that speed.
That date is fine, Your Honor.
Okay, very good. Mr. Ewing, does that work for you?
Mr. Balg?
Yes, that date is fine.
Okay, very good. We'll see you both. We'll see you all back on March 14th at 10:30. Please have your clients with you.
I will, Your Honor. Thank you.
Thank you.
Have a good weekend.
You as well.
All right. Can we get back to the matter at
Okay,
hand?
and Mr.
We got why not jail? Shemke? Is it Shemke? It's got a nice backdrop. It's like feng shui, perfectly balanced.
Okay, Mr. Baig, has there been I hit unmute for the jail, but they haven't unmuted, so I haven't moved them in there yet. Good morning, Mr. Shemke. I'm going to move you in a breakout room as soon as the jail unmutes.
Judge.
Hey, Mr. Baig, are you ready to, is there a resolution with you and Mr. Wilson?
There's no resolution. We'll just argue the motion briefly.
Let's move just a little bit.
Can be just a bit.
All right, we are
We're
back on the record in the matter of Branson versus Collins. And so, counsel, did we obtain the other text messages between June 19th or June 18th and June 27th?
I obtained a more comprehensive view. It's still not clear what the entire conversation is.
Well, here's my question. Why am I receiving as exhibits partial conversations?
That's a good question.
Ms. Collins?
Just to show that I sent that there was a bug problem.
No, hold on. But counsel, you've submitted these, right?
Yes.
Did you look at them before you submitted them?
I did, yes.
And did you notice that there is a huge gap between June 18th and June 27th?
Yes, and I was anticipating laying a foundation and questioning a witness.
Which witness?
Both Mr. Branson and Ms. Collins.
Okay. Did you show Attorney Amy? I'm very elementary when I say that, but I'm very sorry. Have you shown Attorney Amy though that
Not yet.
comprehensive list?
No.
Please show that to Attorney Amy.
Okay, yeah. I won't.
It sounds like she did a rush.
Thank you.
There you go.
I'd like to take a look at those. I'm not necessarily going to look to read them for any
Content.
substance, because obviously Attorney Amy has not had a chance to review these. However, I'm trying to
See if they're complete as to
doesn't
dates.
even have dates on here. January 23rd. Oh, that's the date that's screenshotted or something? I don't know what this even means.
In Your Honor, if I may, just for the record, if you look to the far right-hand column of the thing, that's the first time a date appears, and it appears to be at June 9th.
June 9th, June 10th. There's also Monday, June 10th. Okay, that's not even the relevant time frame.
Your Honor, I can point out the text message where it starts on Tuesday, June 18th, which is separately submitted. Yeah, it's the same text message.
That's awesome, Evangeline.
That's not, okay. If text message conversations are going to be proposed for an exhibit, and this court is being requested to rely on the text message conversations to prove something that you're alleging, I need a full and complete conversation, not piecemeal. I'm not accepting those if they're piecemeal. Mr. Branson.
Yes, ma'am.
Your testimony is that you have these on your phone.
Yes.
Okay.
Yes.
Your phone is out in your vehicle?
Yes, ma'am.
Hurry. Please go out to your vehicle to grab your phone.
Yes, ma'am.
Thank you.
Please run. Meanwhile, I'm going to take this
While we're
brief
doing that, I'm
issue.
going to handle these matters right here. Mr. Beckstein?
Yes, Your Honor.
All right, let me just see here. You're on the LVNB funding versus Nicholas Sarastulo, correct?
That's correct.
Okay, we don't have the Nicholas Sarastulo that's checked in, correct, Terry?
That's correct.
Okay. And Attorney Royce, good morning.
While she's talking to these people, let me turn
Good
this
morning,
down.
Your Honor.
All right, we're just waiting to see if Defendant DeVoy is appearing.
He does.
Okay.
Okay. So we are on the record in the matter of LVNB Funding LLC versus Nicholas Sarastulo, 2302342. And counsel, your appearance for the record, please.
Good morning, Your Honor. Michael Bankstein, P69778 on behalf of LVNB Funding.
Okay, is that BECK?
BENKSTEIN.
Okay, and the court will note that this matter was scheduled for 10 a.m. It is 11:07 and defendant has not checked in. Counsel, this is the date for the pretrial as well as your motion for summary disposition, and you may proceed.
Thank you, Your Honor. Without belaboring all the details in the brief, I'll just bring up a few highlights. Again, our office did not receive a response from defendant to our motion for summary disposition and is not present today. Defendant opened the account, accepted funds, made 23 payments on the account, then stopped paying on the account. Defendant has not demonstrated that there's any material issue of fact and dispute, and plaintiff is entitled to judgment. I'm asking the court to grant our motion for summary disposition.
Okay, and under which court rule is that, counsel?
That would be under MCR 2.116 C 9 and 10.
Okay, and the court will note that the court does not receive anything in response to this motion, and
Judgment for the plaintiff.
that the court does not find any issue of genuine issue of material fact, and the court will grant plaintiff's motion pursuant to MCR 2.116 C9 and C10.
That's what happens when you
And
don't
I've
show up
attached
in court.
to the back, behind all the exhibits, proposed order, Your Honor.
We're hopping between trials in the same court. We haven't done this one before. Not like this. Not back and forth to the same issue. The last time they were in court, the lawyer had somebody helping her who was filming from the gallery, had her phone confiscated by the bailiff. This is after. This is not the time that there was a swingers accusation against the judge. This hearing has, every time they show up before this judge, it just gets stranger and stranger.
All right, so now what I have to figure out is how I get the order off of the motion for summary disposition that you attached, because I can't sign it just on the My File system where it's attached to a motion. So can you take that and can you submit it as a document, please?
I sure can, Your Honor. We'll submit that proposed order to the court via My File.
Okay.
All right. He's back in with his phone. He's showing his lawyer. She gets to review it first. They get the upper hand.
Okay. They have not yet fixed that problem with My File, so hopefully in a few years they will. Okay. All right, thank you. Have a good day.
Thank you, Your Honor. Have a great day.
Okay, and so do we have the phone? We're back on the record in the matter of Branson.
Yes, Your Honor, we do have the phone. I'm trying to scroll back to the date. There's a significant amount of text messages between parties.
Okay, so I'm going to ask this. When you get to that point, I'm going to handle one more on the record. When you get to that point, counsel, if you can show Ms. Teklala, so if the two of you can go out into the lobby for that so that it's not pulling on the record, okay?
I have to object because you can go into a phone and line item delete text messages.
Counsel, I'm very aware of that. I just right now want for you, the two of you, to see if those exist and to look at those right there.
Okay.
Okay?
Okay.
And ma'am, we will then determine whether or not you have any different ones on your phone. We're going to do this piecemeal, okay? That's how we're going to do it, step by step.
Your Honor, if I could just make a brief argument regarding this. The defendant is claiming a defense to this eviction proceeding with her motion to dismiss them. She carries the burden of proof in this case to prove what she's saying is true. My client carries no burden to prove her case and defend himself against her case. Defendant came in here today utterly unprepared. And quite frankly, I believe that she came in here with the intent to do trial by ambush by providing intentionally only piecemeal copies of these text message records.
I'm aware as to where the burden lies as far as this motion to dismiss. Right now, I'm not necessarily stating that I'm looking to see the truth of anything within these text messages. Right now, I'm trying to verify something. So please, if you will just please humor me and follow this exercise.
Of course, Your Honor.
Okay, thank you.
Just go through the motions.
So we are
You're probably
on
going to
record
win.
in the matter of Midland Funding, or Midland Credit Management versus Thomas Wilson, 2400761.
Carol, I believe
Good
they
morning, Your Honor. Jay Bagg, P36820, appearing on behalf of plaintiff.
All right. And I'm sorry, Counselor, can you please spell your last name?
B as in boy, AIG as in girl, bar number 36820.
Balg.
Okay, and Mr.
Just like it
Wilson,
sounds.
your name for the record, can you please unmute and tell me your name?
The bailiff is keeping the parties separated. You got to keep them separated.
Thomas Wilson.
Okay.
He's like,
All right, and counsel, today is the date scheduled for the pretrial in this matter, as well as plaintiff's motion for summary disposition. The two of you were able to speak in a breakout room, correct?
Yes, we're unable to settle it at this time, so I'm going to go ahead with the motion, and I'll just argue it very briefly.
I'm sorry, what was that, counsel?
I will argue the motion very briefly.
Okay, Mr. Wilson, you spoke with counsel, correct?
Yes, Your Honor.
And do you dispute that there's money, that you owe the money?
No, Your Honor, I don't.
Is it a matter of ability to pay?
Right, I don't have very much money.
Okay, and counsel, what's the total amount that your client's looking for?
It's $6,768.01. That includes court costs of $117.03 and damages of $6,650.98.
Okay, and so have you been able to work out any sort of payment arrangement with Mr. Wilson, or is your client not interested in that?
It's based on what we discussed. He's not in a position even to do that. We did discuss perhaps maybe in the future a lump sum. I couldn't commit to it, but I gave him some guidelines. If he said he might be able to borrow some money from family, but at this time we'd like to have a judgment based on the motion under C9 and C10.
Okay, all right, counsel, you may proceed with your motion.
Okay, Your Honor, just briefly, this is a motion under MCR 2.116 C9 and C10. Also based on MCL 600.2145, in particular, that use of the account constitutes a contract. We've supplied quite a bit of documentary evidence showing purchases and payments, local purchases and payments on the account. He hasn't filed a response, so at this time we're requesting that the motion be granted.
All right, Mr. Wilson, I know that you did not file a response, a written response as required. Have you been able to you don't dispute the amount owed, correct, sir?
No, Your Honor, that sounds about right.
Sounds like the judgment's going
Okay.
against him.
You just not be able to make the payments.
Correct.
Okay. All right. Well, the court does find that that a genuine issue of material fact does not exist, and that the plaintiff's motion is granted. Defendant has not filed a motion, a response to the motion, nor an affidavit is required. The court does find pursuant to MCR 2.116 C9 and C10, as well as MCL 600.2415, that plaintiff's motion is granted, and the court will, in judgment, will enter for the plaintiff in the amount requested as stated. And I think that was $6,307. I think I got those numbers wrong.
Let's see. It's a total of $6,768.01 total.
And the court will sign that judgment upon receipt.
Thank you. We'll e-file it. Thank you.
Thank you. Have a good day.
You too.
Thank you.
All right, back to the matter at hand.
Okay, so counsel, we're back on the record in the matter of Branson versus Collins. Were you able to view Mr. Branson's phone for the dates between June 18th and June 27th?
Yes.
Okay, and are there text messages between the parties on those dates regarding the bugs?
There are several text messages.
Are there any regarding bugs?
Yes.
Okay, now, I'm going to have you all go out there with Ms. Collins's phone, have her turn on her phone, get to that date.
Wait.
And you saw Mr. Branson's phone, correct, Miss Amy?
I did, Your Honor.
Miss Amy, now I feel like I really am.
I actually prefer that. I like attorney Amy with Amy.
And so please take Mr. Branson's phone out with you, counsel. And then you can compare the two phones to see if there's any messages that are not there. Okay?
All right, thank you very much.
All right. Mr. Wilson, you're all set. Thank you. Have a good day.
Oh, thank you, Your Honor.
You're welcome. Okay, I'm just waiting for the chair to log back in. Well,
Mr. Wilson's like, well, I wanted to stay and watch how this one ends.
well, I just moved to the main session. Let's see what we do.
Uh-oh.
Is there any way we can have the security officer standing by? Because she doesn't like anybody's touching her phone.
Well, I have court officers out there, so they're aware. Yes.
Can we have a bailiff standing by? She doesn't
Mr.
like
Royce?
us touching her phone.
Yes, Your Honor.
Okay. The court is going, yes, if you can tell them to log off and log back in because they didn't move.
I'll go back. Is that okay?
Who's back there?
Fine.
Can you just message them in case they all come back in? We're on the record in the matter of Calvary SPV1 LLC versus Thomas DeVoy 2400377. And counsel, your appearance, please.
Yes, Your Honor. Christopher Royce, P49102 on behalf of the plaintiff.
The bailiff's like, I'm nervous.
I just texted him and told him, there you go.
Thank you. Okay.
I'm nervous. I want to be out
All
there in
right,
case there's a
and
fight.
counsel, today's date scheduled for the pretrial in this matter, and there has not been a response filed.
Yes, Your Honor. And I would also note that the defendant also failed to appear on the prior hearing that was scheduled. I think that Your Honor was gone, but your assistant had noted in the file that the defendant also failed to appear at that time. I would just request the entry of a default judgment.
Okay, you may proceed with the details.
Okay, I'm flying a little bit blind because our
computers are down.
For some reason, my computer program that does this, but I think the amount of the claim is $5,325.45. Costs of $125.01 for a total of $5,448.48.
Okay. Let me just confirm on the complaint for you, counsel.
Mr. Wilson logged in from inside the courtroom in a.
I apologize that it just crashed on me and I haven't been able to get back into it.
Okay, I'm showing $5,325.47 as of February.
And then costs of $125.01.
And that was of 24. Okay. All right. So, okay, the court will note the defendant has failed to plead, failed to appear for the multiple court hearings that we've had, and therefore the court does find that the defendant is not intending on participating in these matters. Therefore, the court does find by default judgment in favor of the plaintiff in the amount of $5,448.48. And the court will sign that upon receipt, counsel.
Great. Thank you, Your Honor.
Now
Thank you. Have a good day.
Thank you so much.
I'm sorry, just for the record.
Too late.
But just for the record, this matter is scheduled for 10:45 and is now 11:24 a.m. And defendant's not checked in, not contacted the court. Okay. All right, and Mr. Shumke, are you ready to proceed on these matters?
I am, Your Honor.
Okay, who do we have first?
That is Mr. Parkinson.
Okay, we're on the record in the matter of the City of Wyandotte versus Jeffrey Parkinson, 224. Counsel, your appearance, please.
Good morning, Your Honor. Christopher Shumke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom. As to the arraignment, we waive formal reading. My client stands muted.
Thank you. Mr. Parkinson, your name for the record, please.
I'm Jeffrey Parkinson.
Okay, the court will waive the formal reading, enter plea of not guilty for purpose of the arraignment. Schedule this matter for a pretrial on March 5th at 10:45 a.m. And counsel, as to bond.
Yeah, my client's not on probation or parole. He's 58 years old. He hasn't had any sort of trouble since 2010, when he successfully completed probation on an impaired driving. He lives in Detroit with his wife and his son. He is gainfully employed. He's a teacher for high school, teaches English. Judge, I don't believe he's a flight risk. Judge, as to the nature of the bond, I would be respectfully requesting consideration for a personal bond. Thank you, Judge.
Sir, where do you teach? Sir, where do you teach?
Detroit Public Schools.
Okay, do you float around to different schools, or do you have a particular school you're assigned to?
Western International.
Okay, and sir, you have a couple alcohol-related driving offenses, so it appears as though alcohol does not seem to be your friend.
Right.
And you're not currently out on bond in any other jurisdiction, correct?
That's correct.
Sounds like a DUI.
Okay, well, here's what the court's going to do, sir. The court's going to help you in your troubles with alcohol. The court's going to order a $10,000 personal bond, not to be released without an alcohol tether through the Wayne County Jail.
Sober link.
And then we'll see you back on March 5th. The court wants to ensure the safety of the public, and we can do that by having an alcohol tether for you, sir.
Looks like he wants to say something.
Okay, have a good day, sir. Okay, have you already spoken to Brian Gray?
I have, Your Honor.
Ask me something?
No.
Wait, I'm sorry, Brian Gray?
I'm gonna go get him. I'll be back in just a second.
Okay. And so just by way of, just by yes or no, are there any missing text messages on the Branson versus Collins matter when both counsel were comparing the phones?
No, Your Honor.
No. Okay, very good.
Nobody deleted texts. That's a good thing.
Are any objections to the court reviewing the text messages, since now we know that there are not any missing text messages between those dates?
Your Honor, I have no objection about reviewing the text messages. However, I would say that it is not, between, we reviewed what you've asked us to review, which is between July 18th, June 18th, and June 27th. However, there are other text messages past that date that are relevant to this conversation about the bugs, including text messages where the bugs have been completely eradicated.
Okay, and I'm not saying that we won't, I just wanted to get those dates, the messages between those dates secured. Are the messages regarding that Counsel Amy is referencing, are those included in the documents that were submitted?
No, I'm not aware of that.
You're not aware of what?
The eradication of the bug issue.
Okay. Whose phone are those on?
They're on my client's phone, but they should be on her client's phone as well.
Okay, good. I'm gonna have the four of you go out into the lobby and compare those.
Sure.
Thank you. All right, we are back on the record.
The judge is giving
In the matter
lessons.
of the city of Wyandotte
The bailiff
versus
steps up.
Brian Gray, 25225. And counsel, your appearance, please.
Good morning, Your Honor. Christopher Shemke, we have my client. This time, we consent to the matter being heard via Zoom. As to the arraignment, we waive formal reading. My client stands mute.
Thank you. And Mr. Brian, your name, or Mr. Gray, your name for the record, please.
It is Brian Gray.
All right, thank you. Today's the date scheduled for the arraignment in this matter, based upon your current status in the Wyandotte jail. And the court will waive the formal reading, enter a plea of not guilty for purpose of the arraignment, and schedule this matter for pre-trial on March 5th at 10:30 a.m. as to bond counsel.
Your Honor, as to bond, my client's not been in any sort of trouble since 2012. Judge, he's not on probation or parole. He's 31 years old. He is gainfully employed. Indicates he will appear at any and all future court dates. I would respect the request consideration for a personal bond. Thank you, Your Honor.
All right, thank you, sir. Where is it that you reside?
Oh, I'm sorry. I live in Meldendale right now. Like, it's a motel. I'm staying there. It's closer to work.
Okay, where do you work, sir?
Quality Care Moving.
Okay, how long have you been residing in Meldendale?
For a couple weeks now.
Okay, what happened with your matter in January 24 in Monroe?
I had a car problem. My brakes failed in my car, and
Listen, let me clarify. I don't want the circumstances. Did that matter in Monroe, the operating while intoxicated, did that get resolved?
it has not. No,
Why has it not been resolved, sir?
because I never got anything. I haven't heard anything from them, to be honest with you.
And you didn't contact the court to follow up, sir?
I have not. I've been. That's all I've been doing is working.
Well,
I guess I fell through the cracks.
were you working last night when you were at Wyandotte Tobacco and More?
I just had gotten off
Yes,
work.
no. Were you working at that time?
No, ma'am.
Okay, so that's not the only thing you do.
This judge does not like excuses.
Sir, it's allowed you at a point, it's allowed you were pretty,
Soused. Say it, Judge.
pretty intoxicated at 0.25. So, sir,
0.25?
you were charged with operating while intoxicated and no license in January of 24 from Monroe County. And you have not taken care of it, sir. So it's very possible there's a warrant for your arrest because the default entered onto your driving record and your driving status is suspended. So do you drive for?
No. No, I'm a laborer. No.
All right. Well, the court does have some concerns, sir. Well, are you out on bond in any other jurisdiction?
No.
Are you on probation or parole anywhere?
No.
All right, and clearly you failed to appear in court because that's in Monroe. And so the court, sir, is going to order a $5,000 10% bond. In the event you post bond, sir, alcohol tether through the Wayne County Jail. You're not to possess or consume any alcohol or drugs unless prescribed. Okay, thank you. Have a good day.
Thank you as well.
Thank you. All right, off the record. And everybody?
Okay, is everybody
Mr.
still out?
Shumke, I think that's everybody.
I believe so. There might be something later today, but I'll be on standby.
Thank you. Okay. All right. So, Terry, can you hear me the last time, please? Can you hear me the last time,
It's a safe place for me to go. Up
So
here,
we are
here, down here.
back on the record in the matter of Branson versus Collins. And so, counsel, you both had an opportunity to review the subsequent text messages after June 27th, correct?
Correct. That is not correct, Your Honor. The defendant walked away and did not allow me to actually look at her phone. She literally walked away from the conversation.
Don't interrupt, please.
And I asked her counsel whether or not there were text messages subsequent to the one that we have on August 18th. We had not been able to, because we have.
August 18th?
Yeah, so we have a text message specifically on August 18th. Hey, the guy came out, he sprayed, this should take care of it. She says, thank you. That's the last text message my client has related to any book issues.
All right, okay. Do you have any of those text messages, ma'am?
Yes, ma'am. Is she allowed to be using her phone at this moment?
As long as she's just looking through her text messages. So, Mr. Klala, did you see on your client's phone the part about the bugs being eradicated and your client saying thank you?
I saw that conversation. I don't consider it proof of any eradication of.
That wasn't my question.
Okay, I saw what you're referring to.
Okay. Did your client allow Attorney Amy to view the text messages that you were viewing?
No, but that was an accident, Your Honor. She walked away. I thought we were just confirming that they both had that text message.
We were, but you were, the two of you were. How is Attorney Amy supposed to do that if your client walked away with her phone?
Okay, yeah, you're absolutely right. I'm sorry.
Go back out in the hall.
So the message that somebody came out to spray for the bugs and your client saying thank you, that doesn't mean that those were eradicated.
No, they weren't. There's still a bug issue.
Okay, when did your client then re-notice Mr. Branson regarding the bug issue?
I have to ask her the specific date if she can recall it.
Okay, here's some concern that I have here. Your client is alleging this matter should be dismissed because the home is not habitable, okay, or it's not fit for living properly. Did you find the text message? Don't stop looking until you find the text message, please.
Don't you put your phone down in my court.
A plethora of text messages that are incomplete. So I should not have to be the one to essentially babysit step by step how the evidence should be brought forth and communicated between counsel. I should not have to do that. But yet I am having to do that.
Yeah, here we are.
Because your client has given you partial information. I don't know if you've attempted to get the information from your client and it's not able to be given to you at the time you're asking. I don't know. But to ask this court to dismiss this matter
to be right here This is the safest
It
place.
didn't say they were eradicated.
What does it say? Is it right there?
Yes.
Okay, show Miss Amy what that is. Attorney Amy, the phone.
They said they're harmless.
That's August 18th?
Yeah, and that's not if you'd like, Your Honor, I'll read the entirety of the text message into the record and they can confirm whether it's accurate or not. If that's.
This is August 18th.
Yes.
Did they say they're
Ma'am,
eradicated?
I'm
They
not
said
asking
they're
for your
harmless.
testimony. I'm asking if you have pulled up the text message that is being referenced regarding
Yes.
somebody coming to spray for the bugs and you saying thank you.
I didn't say thank you, but yes.
Your Honor, the very
Yeah, I
next
did say
time.
thank you. You're right. I did say thank you.
Okay, so I'm going to have you follow along on your client's phone. Attorney Amy, please read into the record
Thank
the
you, Your
date
Honor.
and time and who it's from, please.
Thank you, Your Honor. From Mr. Branson to Ms. Collins on Sunday, August 18th at 2:40 p.m. He identified the bug as a springtail, basically like a gnat. They don't bite, sting, or do anything. Totally harmless. They like damp areas. He recommends every time you shower, use the vent. The underside of the tub is totally dry when we ran a camera under it. Sprayed for them. Google springtails. This should take care of them. Hung the mirror and your doorbell also. I ordered some LED lights. It says LED, but I take that to mean LED lights for the basement as well. And untimed response by Ms. Collins. Thank you so much. When you have a moment, can you please show me how to take the doorbell off and I can hook it to the Wi-Fi and app. Sorry I tried and I felt like I was going to break it. Also, the mirror looks great. Thank you so much. I appreciate it. And then there's one response by my client on the sheet that I have that says there's a small orange tool in the box. Use that to unscrew the set screw on the bottom of the doorbell, then slide it up.
Okay.
Wow. It's a
Did you
different story.
then send, so that sounds to me as though, Mr. Branson fulfilled his obligation at that time as it relates to the bugs. Because he had somebody come out to the home, sprayed for the bugs, determined what type of bug they were, determined that there weren't any leaks because underneath the tub was dry, indicated what type of bug it was, and that it's a bug that, it's a harmless bug in the sense that there's not any, I presume like a bee or something like that, where it would be stinging or something. And that what type of areas that particular bug likes. Now, did the bugs return?
Yes.
What date?
They've been returning off and on.
No, ma'am, it's your burden.
I don't know the exact date.
Ma'am, it's your burden. You have filed a motion to dismiss and you're alleging that there's bugs and that that's a reason why Mr. Branson should not have checked box number
She's
6.
writing
I mean,
huge
7.
letters.
So what other dates have the bugs returned that you communicated that to Mr. Branson?
I can't give you an exact date. So I'm not gonna lie and make one up.
Okay.
If that's what you want me to do.
No, it's not. I don't want you to lie and make one up. Okay, so we'll move on from the bug problem. The kitchen not finished.
Next.
What's wrong with the kitchen?
When I moved in, I was told that I was gonna be getting a whole brand new kitchen. I was shown their kitchen. When I was walked through to look at it, when I moved in, they said, this is the kitchen you're gonna get. I was given, you're gonna have cabinet doors, brand new flooring, everything. And I said, oh, great. They even said, because there's originally one price on Zillow, they said that it's gonna be $1,500 when you move in because we're doing this kitchen.
Hold on. What was the amount on Zillow that you originally were going to rent the property for?
$1,300.
$1,300 a month?
Yes.
Mr. Branson?
For $200, were you gonna replace the kitchen?
What the original rental price was $1,300 per month?
It was also on Biddle
Ma'am,
Street.
hold on. I'm talking to Mr. Branson right now.
Honestly, I don't believe so. I don't have the Zillow thing. My wife puts the Zillow on. And
Okay.
No, the agreed upon with the lease was $1,500. I don't believe it was or $1,300. I'm not going to say in confidence because I don't know what the Zillow.
Did you at any point increase the rental price based upon a new kitchen?
Absolutely not.
Okay.
Or the promise of a new kitchen.
Did you take Miss Collins into your home to show her what kitchen she would be receiving?
She's been in our home, but not for that reason, no.
Okay.
No.
Is there a working kitchen in the property,
Oh, absolutely, yes.
Miss Collins?
Yes. But to be fair, the outlets don't work. For the first 3 months, if I used just one appliance, the entire kitchen wouldn't work.
What's your
Okay.
appliance?
Did you notify Mr. Branson of that?
Yes, I did. And then December 1st, when I found out one of the outlets was start fire, I let him know.
When did you find out an outlet would start fire?
On December 1st, I went into the hospital and I said, could you fix the outlets? I'm in the hospital, I'm out. He said, okay, I'll go in there in the hospital. When I went to try it in November, when I got out of the hospital, I was finally up and I was able to try it on my own. The first time I did on December 1st, I let him know. He rushed over on December 1st, I have it on videotape. He said, well, if it catches on fire, I need to know. And he came into my house. And he was, well, I'm evicting you.
Hold on. If he says if it catches on fire, let me know, doesn't mean that it's an outlet that's going to catch on fire.
No, it's right. It smokes if I plug something in. So he comes over because I said,
smokes?
Yes. I have an
Which
outlet.
outlet are we talking
The
about?
one in my kitchen.
I understand that, ma'am. Which specific outlet?
The one by the back door.
Okay. So, Mr. Branson, the outlet by the back door,
Yes, ma'am.
does it work?
Yes, it works. I mean, she's plugged appliances. There's no evidence of a fire. We have replaced that GFI.
When did you replace the
The
GFI?
first time she complained about it, we replaced and put a brand new GFI.
Okay,
Ground
what
fault
date was that?
interrupt.
Okay, what month?
It would have been right after she made the complaint.
I don't know when that was.
I'm sorry.
December 1st, when I rushed
I don't know
over.
when her first complaint about the GFI was.
Okay, would it have been summer
No, I
or winter?
believe it was in the fall, actually.
Okay, so before she went into the hospital?
She's
Or
been
while she was in the hospital?
No, she was in the hospital when I did that. Yeah. No.
Okay, all right, so the GFI was replaced. Would you agree with that, Ms. Collins?
While I was in the hospital, correct.
Okay. And then your testimony is that even after it was replaced, it still didn't work?
Correct.
Okay. Well, the inspection next week will take care of that. And,
Your Honor, there's a
and you said that there were 3 other outlets that did not work. Where were those? Where are those?
There's one in the dining room that does not work at all.
Okay, you said the kitchen, there are 3 in the kitchen. Is it an eat-in kitchen? Or is there a separate room for dining room?
There's a separate room in the dining room.
Okay, so we're talking about specifically the kitchen.
Oh, there's another one in the kitchen the kitchen, if you were to plug one into the other, then the whole kitchen goes out.
Yeah, I don't know what one into the other means. I need you to be specific for the record, okay? And I also am asking you, you said there are 3 outlets that do not work. Where are those 3 outlets located?
There's, the 2 right there that I was talking
Ma'am,
about,
okay.
that start,
Hold on. You keep saying right there. I don't know where right there
the
is.
one by the back door.
Okay, there's 2 by the back door?
No, I'm talking, to me, 2 outlets are the 2 plugs right there that are together.
Okay, so it's 1 outlet, 2 plugs,
Correct,
not 2 outlets. Okay, so it's 1 outlet with 2 plugs.
correct.
Is there another location in the kitchen that the outlet with 2 plugs does not work?
No, that one, that's
That's the only
yes,
one?
that I know of.
Okay, so what part about the kitchen does not allow for the home to be fit for its intended purpose?
What I was talking about with the kitchen, ma'am, is they baited and switched me with the kitchen. And I have proof of that.
Okay, what's your proof of that?
My proof of that is text over and over, and then in the hospital, they finally said,
Okay, where are those text messages?
can I show you on my phone?
Well, are those included in any of these exhibits? Because we have 105 pages of exhibits, which I'm presuming, since the kitchen is an issue, that it's going to be in here somewhere.
I know, I gave them to her to submit.
Great. Throw your lawyer under the bus. She'll appreciate that.
While she's looking, if I may, Your Honor, just a
Yes.
brief
The
argument.
fridge and stove are coming
Oh, hold on,
in.
ma'am, I'm asking you to look for them, not read them right now.
Thank you, Your Honor. Even if what Ms. Collins is saying is true, which we disagree with, it doesn't make the kitchen uninhabitable. It doesn't make the house unlivable to the point where she can evade any form of rent for that. Moreover, every conversation that they had about like possibly remodeling the kitchen was put off because Ms. Collins indicated she had cancer. And they didn't want to go in and do a major construction project while Ms. Collins has cancer. And if you look at the entirety of the text messages, which she did not submit again, that's what you'll see. You'll see that there was a conversation about possibly remodeling the kitchen and it being put off because Ms. Collins had indicated to the Bransons that she had cancer.
Okay. So, yeah, when was there a conversation about remodeling the kitchen?
The remodeling in the kitchen was, they're supposed to be done before I even moved in because I signed the lease May, I believe, 24th. I didn't move in until June 17th. It was supposed to be done before
So
that.
hold on, but I think I saw somewhere that you were dropping things off June 2nd. So you had access to the property.
Upstairs.
You had access to the property June 2nd. So whether or not you moved in fully after that, I don't know, but you had access to the property before that. I recall from the last time, from 2 times ago, that you made the argument that you were not in there for the full month of June, so you should have an abatement for certain dates of that. You had access to the property and you moved some items in June 2nd. Whether you moved the rest of them in or not after that, absent some reason that stems from the home not being ready to move in, I don't see that that's a basis to abate any portion or prorate any portion of June. However, the kitchen being remodeled or not being remodeled, and you're told it would be remodeled, if that's what the conversation was, and it wasn't remodeled, I don't find that that would be a basis to find the home not fit for habitability. And was there a discussion to raise the rent after the kitchen was renovated?
No, absolutely not. I've never raised the rent. I have no intentions of raising rent.
Okay. Ms. Ekbalo, what do you have there?
Exhibit 6 contains text messages about the kitchen. Your Honor's probably not gonna love it because it's the similar format as before.
Well, you're correct. July 24th.
Also, I'm at a little bit of a loss. I thought we were arguing a motion for summary disposition based on the certificate of occupancy. So I was intending to call witnesses for a, evidentiary hearing and cross-examine them and lay a foundation for these exhibits for those underlying issues.
Your Honor, I warned opposing counsel that she was mistaken. I gave her fair warning via email, in writing. I think this court is actually purview to those conversations. I think they have happened in line with the conversations related to the proposed order that Your Honor had the ability to view this morning. And instead of double checking and crossing her T's and dotting her I's, Ms. Ekbalo came in here unprepared for this hearing after submitting documents that are inappropriate and abjectly in violation of the Michigan court rules and rules of evidence.
Your Honor, I'm a little tired from opposing counsel trying to throw the evidence under the bus and say this, that, or the other thing, when all I'm saying is there's procedure to be followed for a motion for summary disposition based on immunity granted by law compared to a full evidentiary hearing while I'm calling the witness.
What immunity are we speaking of? Because because the court ruled on, in fact, let me pull it up. The court ruled when the parties were first here on the 14th, that Ms. Collins was going to be relocating. She, number one, stated she wanted to relocate, and the court ruled that the plaintiff is entitled to recover possession of the property. What we were,
Look at the plaintiff.
what we,
Or look at the
what I ordered the parties to brief was the issue of where the money that's held in escrow is to be released based upon two things. Number one, your client indicating that she didn't have access to the property for the month of June or couldn't move in until June 17th, so she wanted a prorated amount. Also, because your client alleged that that the certificate of occupancy plays a role in where that rent money that's been deposited in escrow goes. You subsequently filed an appearance. Actually, let me just see something here. That was on the January 14th date. We set this for an in-person trial for February 7th. And that's when the court entered the escrow order as well. Then on February 11th,
plaintiff attorney's checking her watch. She's like, I've got work to do.
because I must have gotten moved February 11th. February 11th, the hearing was held. We adjourned for the next hearing to address the issues. June 2024 rent, defendant claiming she overpaid utilities, plaintiff going in all hours of the night, stealing mail and harassment. Also, parties to brief the issue of no certificate of occupancy and collection of rent. Then we moved into the 18th, and I had originally stated the wrong time. And then the parties were here on the 18th, except for Ms. Collins. She was present earlier, even though we noticed everybody that the time was changed. And we adjourned the matter today regarding the escrow money and utilities and two other issues that the court stated. You also, counsel, at that time, wanted to address your motion, amended motion to dismiss. So that's what we're still on. We're still on the amended motion to dismiss. I started with that because if I'm granting that, then the rest of the matters appear to be moot as far as that goes. However, so that's where we're at right now. So that is what we're here for. So as it relates to the kitchen, what does that state? What is that? And I will also make a statement regarding the evidence. And counsel, you've submitted evidence that is incomplete. You've submitted these exhibits that are incomplete.
Which is improper.
I suppose I was just looking for clarification from the court why, to me, this is a motion for summary disposition under 2.116C7 and C8. It's not an evidentiary hearing, so I have testimony, and to not be able to, take testimony of someone that I'm calling with evidence that I can build a foundation for, it's just procedurally, I can't understand. I do understand that you're allowing, and thank you, allowing to hear argumentation on habitability for the number 7 that was checked. I do understand that and appreciate that.
How's that different from
Motion
just
for summary
arguments?
disposition wasn't filed, so this is not a summary disposition matter. A motion to dismiss was filed by your client. An amended motion to dismiss was filed by your client. You're relying on that motion that was filed and then submitted additional exhibits. So we're back to the kitchen.
Could you do me a favor and give me the court rule for the motion to dismiss?
The court rule?
Yes.
Your client filed the court. I don't know what she filed it under.
I don't think she filed it under any court rule.
Well, then I guess, you're claiming that it's, let's see here, property item 7. That is what she referenced. Or, I'm sorry, item 7, non-payment of rent for residential property, item 7.
I'm just asking for the court rule so I can have some guidance in terms of the motion to dismiss compared to my interpretation of it substantively was more of a motion for summary disposition. So if I could please, if I had the court rule for the dismissal that we're operating under, maybe I could have more clarity there.
Well, presumably I'm operating under 2.119, which is a motion, and your client filed a motion to dismiss. 2.116 is a motion for a summary disposition, and there has to be a 28-day notice, and there has to be a time for response to be filed, affidavits, and all that. This was not filed as a motion for summary disposition. This was not filed that way. So we're proceeding as a motion to dismiss.
I don't believe she filed it in the first place. I filed a brief.
Who filed the motion to dismiss, this handwritten motion? Who filed this motion?
That is an exhibit. It wasn't filed. You had ordered briefs, and she had written that before.
No. This was filed.
Oh, fine.
This was filed.
Okay.
Prior to your appearance, counsel, this was filed because this is what we did not proceed on February 7th because there hadn't been sufficient notice to plaintiff.
Okay.
So that is why we are handling it in its entirety now, because now everybody's here, everybody's present. That is what we're doing. So, but if you want to stipulate that the property was habitable and we don't need to have further inquiry regarding item 7, then we can proceed with the next issues. That's fine. Or we can continue to proceed with whether or not the property was kept fit for its intended purpose pursuant to number 7 on the complaint for recovery of possession of the property.
Okay, I would like to request a continuance, please. For the reason that I was under the impression we were arguing in terms of the disposition of this case under the law in regard to MCR 4.201 and MCL 125.530. I'd like to re-subpoena the witness that I had subpoenaed for Tuesday's hearing in order to have her present.
Which individual is that?
It is Kelly Roberts. She works for buildings for the city of Wyandotte.
Okay. You subpoenaed her to be here this past Tuesday?
Yeah.
Was she here?
No, she wasn't.
No, she was not. Okay. So what does Ms. Roberts' presence or testimony, what's the relevance regarding the motion to dismiss?
I want to ask her about any former inspections of the property.
That would be as it relates to the
occupancy.
The money held in escrow as to where that goes, but I don't know that I need her testimony for that, but that I'll defer that for just a moment. What does that have to do with the motion to dismiss?
What it has to do with the motion to dismiss is, again, going back to how this is a little convoluted in my brain, because you have MCR 4.201, which dictates that residential properties have to be kept fit for their intended use and purpose, and habitable as it relates to number 7. Then you have MCL 125.30. So to me, if there's no certificate of compliance, and then on top of it, factually, it's not being kept fit for use, especially with the amount of evidence and the amount of issues. If I have testimony from a city employee stating that there's a history of problems at the residence, or some further information that could push the burden of proof so I can actually get my client the justice that I'm attempting to get now, that's why I'm asking.
Push the burden of proof for justice. There we go.
Okay, if you may please support. First and foremost, my client has been delaying this. Like, this has been pushed out a number of times, like a multitude of times, and we're here today. Client's mistake of what was going on because she misunderstood the nature of summary proceedings as opposed to a summary disposition motion. I don't think it's good grounds to continue to delay this. This court has already ruled that this tenant must leave the property, and now it's about where the money goes. The defendant has the burden of proving whether or not there should be some money released to her or all of the money should be released to her. That's her burden. And she came without evidence. Even the evidence that's in here is not relevant. Moreover, the witness that she was trying to call from the building department as it relates to habitability is not necessary, nor is it relevant, because the past history has nothing to do with what's going on today. And the actual condition of the property as it sits today, Your Honor. So that witness is irrelevant. And the reason that witness didn't show up last time is because sister counsel subpoenaed her incorrectly. A subpoena was submitted to the city via email 3 days before the hearing. when the court rule clearly requires 7-day notice with personal service of a subpoena for a witness to appear. So sister counsel didn't even do that correctly to get her witness here. And she could have, there wasn't even enough, she could have subpoenaed her for today, but she made no effort to do so. And if her claim is that this witness goes to where the money goes, that issue is before the court properly, because even if we're not having the full proceeding today, that issue, the specific issue of where the money goes after this hearing is over and you make a determination of habitability, would have happened today, pursuant to the defendant's own motion. And it is further clear that the express language of the statute that we're talking about, which is actually, hang on. Which is actually MCL 125.528 or 125.530 subsection 5 dictates where that money goes. And the money is supposed to be held by the city. And the money is supposed to be released to the plaintiff for the purposes of completing repairs due to the express language of that statute. And after whatever's left over, after he has been reimbursed for the repairs, is intended to be released to the landlord. It is clear. The statute is clear and unambiguous in its terms that that is what happens with the money that is held in escrow, Your Honor. So that witness would have been more appropriately here for the motion for the motion to dismiss. And as it relates to the issues that were brought forth by the defendant in her motion, and she's not here today. And that witness is not relevant to move forward to proceed on the issues of habitability, Your Honor, because that witness has not inspected this property.
I actually, I sent an email to the witness as a courtesy. I sent it out, priority mailing, but I was retained 4 days before this was, I'm just a little tired of hearing, I didn't do my job, I didn't do my job, I didn't do my job. When I'm not talking about that. Yes, there's a burden of proof. Yes, there's evidence. I'm talking about being able to fairly get testimony from the witnesses I intend to call and to be able to lay a foundation for my evidence. Because a lot of this is trending into what my client's defenses are. It's not relevant to the motion to dismiss, it's what her defenses are.
Okay, what are your client's defenses?
Well, my client's defenses obviously primarily is that it wasn't fit for use and habitability.
Okay, so your client is stating that when this complaint for non-payment was filed on January 3rd, that the property was not in a habitable condition.
Correct.
Okay. So you subpoenaed Ms. Roberts, you're intending to call Ms. Roberts as a witness to address the habitability of the property.
Correct.
Okay. When did she go in to look at the property?
I don't think that she has.
How would her testimony be relevant?
Because she's the custodian of records for the buildings department.
Okay. But if she has not looked at the property, how can she determine what issues would affect habitability?
I would be more than happy to talk about what issues affect habitability after the inspection is done that's scheduled on Wednesday. But I'm absolutely insisting that someone from the city provide testimony related to this property.
Okay. Has the property been condemned?
No, Your Honor, it has not.
Okay. So have there been
How do we get this far without that question being
citations
asked?
issued to Mr. Branson regarding property maintenance violations?
No, Your Honor, it has not.
Has there been any documentation that would suggest that the property in and of itself is not habitable?
No, Your Honor, there hasn't.
Ms. Iqbala?
So I have significant evidence from my client. There are several pictures that have been submitted to the court.
Okay, let me clarify. Any of those photos, do those render the premises inhabitable?
Yes, the mold issue.
The mold issue, okay. When did the mold issue begin?
Let's go there.
Before I moved in.
Okay.
How do you know?
Did you look at the property before you moved in?
Yes, and I asked him, he told me it wasn't mold. And
Okay, did you have a mold test done?
No, I believed him.
Then how do you know that it's mold?
No, I've now since.
Okay, where's the mold test?
I'm getting it back right now, and I'm also.
When did you
getting
have
it
the mold
home.
test completed?
About 3 weeks ago.
Okay,
That's the
Which photo is alleging the mold? Let me get to that. Which photo is alleging the mold?
Judge, may I? I think I can help the court.
What's that?
The photographs provided by the defendant in this case are all black and white. It would be absolutely impossible for you to look at those photographs to make any form of determination.
Oh, is this where Miss Ashley comes in, where she's got color
That's right.
photos that she's gonna screen share?
Not only color photos, but we have the body cam. And we've been able to, the body cam for the police is extremely
Does the body cam show any of the alleged mold spots?
I believe it
No, I'm not
does.
asking for belief. I want to know, does it?
It does.
It doesn't show any mold spots because no mold spots exist, but it does show the general condition of the area in which this defendant claims there is mold.
Okay, Ms. Miller, I really need for you to please stop talking Collins, while somebody else is talking, because it's affecting the record. Okay, and I'm having a hard time focusing on what's being said, because I'm hearing you talking. I don't know exactly what it is you're saying, but I'm just hearing noise that way. So, where are the photos? So the photos had to come from somewhere. Were they on a phone?
No, and I do have color copies.
See the color copies, please.
I have black and white here.
Well, then why don't we have the color copies here?
Because I need a continuance. I need more time to adjust my exhibits and to be able to run this effectively.
Well,
You had time to print them in black and white.
if there's an allegation of mold, I'm not sure why the color copies weren't brought. Was it on somebody's phone?
No. What?
Your phone?
Yes. Okay.
Let's go out in the lobby again and look at
I
your phone.
received actual printout pictures. That's why I said no. I wasn't aware of it.
Okay.
The soul just left her body with that sigh. Okay. The sad truth is this sort of dispute happens every single day, and there are landlord-tenant issues, and they are real. And I feel for people who are in a situation where they have made an agreement and they're not getting their portion of what they're paying for. Okay, it's real. I'm not laughing at that matter. This has become a circus in the way this lawyer, I would say predominantly, I'm going to blame the lawyer. I know she came in late. This lawyer and her client have tried to swing for the fences and what they got. Maybe she has a valid claim. Okay, maybe there was, well, we found out there was the kitchen socket actually works. It was fine, and it, they've replaced it. She called and said there's a problem. He arrived the same day and fixed it.
Well,
That's pretty good.
Is Kennedy still available, or?
She's not on here, but I mean, if she wants to zoom back in, I can embed her back in. But wait on that, because I'm not sure if I'm going to view the body cam or not. I don't know.
You might have body cam.
We're killing her vacation trip. I'm sorry. I feel bad for her.
The judge has been chipping away at this pile of pictures that have been submitted today to this, to say, that either it doesn't apply or the evidence isn't met or it's not complete. You want to bring in the text messages, but not the whole thing. You want the text message that says, hey, there's a bug problem, you need to fix it, but not the one where he says, okay, we sprayed it, that should take care of it. And you say, okay, thanks.
Okay, yeah, I'm just looking for you to pull up the pictures.
They're all in different spots, so I have more. They're in
Pull
three different
up
spots.
one. Pull up one for now.
Hand it to the bailiff.
Find the best one. Here's a good one.
Show it to the opposing counsel.
Show it to counsel. Okay, Terry, can you go on the facility, please?
Did you see that?
That's the black one.
I'm not asking for additional comments, I just want the photo, please.
Touch the phone, touch the phone. Yes. That triggered her. That triggers her. Him touching the phone. I'm sorry, that's funny. Now show it to the judge.
Okay, so this is.
Whoa.
Looks like. Okay, where is this photo taken? What room?
In the basement.
The basement. Okay, is it? This looks like there's brick and then maybe cinder block. Okay. Where,
Inside, outside.
okay, this is on the block itself. Is there anything on the walls? Is there any drywall in the basement?
No, Your Honor.
Yeah,
Yes?
there's drywall as well, yes.
There's drywall. Is there drywall in the basement, Mr. Branson?
No, it's an unfinished basement.
Okay. Ma'am, do you know when I say drywall, I'm not speaking of whether or not there's a wall that's dry. Drywall is it's a material
Like a gypsum
that people
board or
put
something?
over 2x4s or whatnot to create actual walls in rooms.
This judge
So,
is jack of all
Is
trades.
there any drywall in the basement? No? Is that no?
No.
Okay. All right, well, is there another,
Your Honor, I have a photo that was submitted in the exhibit, so it is black and white. But you can see a significant spot that could either indicate the leaking itself or the mold, which may go hand in hand.
It might just be water.
Even if it shows either or, but council's own statement is an admission and you can't tell what it is. And let me say this.
I'm gonna look for, grab another picture, please, that shows more of the wall itself there, please, and not just a close-up of the spot, please.
And let me say this, Your Honor, my client purchased in the summer, last summer, a dehumidifier for the basement. It's been running full time. And if there's mold in the basement, let's ask Ms. Collins why she has the basement floor filled with her personal belongings, because everybody knows that if there's mold in an area, the spores will get on your belongings. So she is storing her personal items in a place that she's claiming is filled with black mold. It's inconceivable. It's irreconcilable with
she should have the right to use that
her
space.
current statements.
Okay, why does your client have a dehumidifier in the basement?
Because Ms. Collins had said that it smelled musty. So because it smelled musty, he bought a dehumidifier in the basement, just to appease her, to make the damp smell go out of the basement.
Okay.
Moreover, it's very clear that Ms. Collins did not order a mold test until we were well into these proceedings.
Okay, so Ms. Collins, is that, what did you take a screenshot of?
I'm just showing it closer.
No, I didn't ask for it to be closer.
That's fine.
Show the picture that you just pulled up and you took a screenshot of. I don't want the screenshot, I want the
I'm gonna
picture.
delete the screenshot. There you go, right here.
Please show, Terry, please show council.
I'm gonna get it so it's not cropped or anything, hold on. There you go.
Wants to come over and touch the phone as well. He's doing it just to get under his skin.
Your Honor, can we show this to our client?
Yes, I don't even, what is this a picture of? Where is this picture?
He has, before I moved in, he had, shelves blocking, window. The window I'm saying that's like almost falling off. He has a shelf holding that window
Okay,
in.
this is behind the shelving?
Yeah, that's behind the shelving.
So what part of this are you referencing is the mold? The part of
Right
the
down,
bottom?
yeah, right, all down by
By the
there.
shelf?
Yeah, he's trying to hide it.
Well,
He has stuff on there, behind there.
Ma'am, hold on. That doesn't necessarily show that that's mold. It shows that it could be dark brick or discolored brick. I don't know that. Can you please show that to Mr. Branson?
He has stuff.
Ma'am, when did you become concerned about the mold that you're alleging?
After I got out of the hospital, and they told me that it could be something in my house.
What could be something in your house?
That gave me my disease.
What disease is that?
That I have this low vitamin thing that my body's not reproducing.
Some people would say that's a good thing.
Okay.
Did I say that out loud? I'm
Okay.
sorry, that was rude.
Well-
My apologies.
When did you get out of the hospital the last time when that was stated to you, ma'am?
In October, no,
Okay.
last week of October.
Okay, and so you ordered the mold test 3 weeks ago?
With my doctors that finally put it to me, I first smelled something when I first moved in, and he's
Right, that's why I have the dehumidifier.
Yeah, that's why I put it in there.
Okay. Right. And
But
that's
I was
established.
never, I was never told until like 3 weeks when I moved in that the basement flooded. He sent me a text, oh, by the way, the basement floods.
Okay, hold on. Does the basement flood, Mr. Branson?
No, ma'am, not at all.
Does the basement flood when there's heavy rains?
Absolutely not.
Has the basement ever flooded?
No, ma'am.
Did you ever tell Miss Collins that?
May I address?
Did you ever tell Miss Collins the
No,
basement
no,
floods?
I've never told her the basement floods, because it doesn't. I have an adjoining basement, and I have no flood, never have. I've lived there since 1977. I've never had a flood in that basement.
Okay, and at what point did Mr. Branson tell you that the basement floods?
Within 3 weeks, I'm gonna be honest.
Via
Did the basement flood within those 3 weeks?
The first time it got wet, yes.
It got wet, what does that mean?
The walls got wet and the ground got wet.
How?
Okay, did the ground get wet near where the walls got wet?
Yes.
And would that wall be near where the window is, needs repair?
Yes.
Okay. So, okay, at any point during any of the heavy rains, did you have water covering the entirety of the floor of your basement?
Not.
Yes or no?
No.
No, okay. So it's quite possible that there's some leaking water from the window, went down the wall and on the floor there. That's possible.
We're waiting for this word.
Okay.
Your Honor, Exhibit 7 is a screenshot of a text message from July, and it tends to indicate that Mr. Ranson did know of the flooding in the basement.
Hold on a moment.
Sure.
Exhibit 7.
In fact, Your Honor, it actually says exactly what Mr. Branson said, that the basement has never flooded. But it says, hey, if it's wet down there, let me know, but it's never flooded. Literally, that's what it says. Despite the
Please read it, Judge.
ill-conceived reference that Sister Counsel would like you to make.
Possible. There's nothing.
Hold on, I can't even find that yet. Hold on, I don't even, oh, there we go, I'm coming close, okay. All right.
Somebody's wrong here. The landlord or tenant, one of you just made a claim about this text that's incorrect.
Sorry for the, okay, Tuesday, July 9th at 10:59 p.m. Sorry for the late text, but with the possible heavy rain, make sure you let me know if you're getting wet tonight or tomorrow. And then, Miss Collins responds, would that be in my room or the basement? Sorry if we just get, and then it cuts off.
That's all we needed to judge. You
And
just
then
need
there's
that
nothing
relevant
else
part.
after that.
Yeah, because
And then and I will note that there's a handwritten note on here, which there also shouldn't be handwritten notes attached to exhibits that said new basement floods before I moved in with a question mark. So,
Quit writing on the
And Your
exhibit.
Honor, the reason she cropped that is because the next text message chain, which me and both Ms. Davala were able to view when I was scrolling through my client's phone, clearly states, no, it's never flooded. Like, it literally says that. That's why she cropped
did you
it.
both review that, Counsel?
I was looking at the bug problem, so honestly, I, probably should have been paying attention more, but.
Okay, well, I mean, you're focused on them, that was the purpose of looking was for the bug problem. Okay, where's that message?
We're pulling it up, Your Honor.
This was supposed to be a brief
Your
hearing.
Honor, can you give us
It's
the
now,
date of that again, please?
it's now consumed
July
the
9th.
court's day. Looks like Judge DeSanto is now on. Looks like Foreign Islands for Sale website. She's looking to get away now. Scroll. He's using the middle finger to scroll, effectively giving us all the bird. You know, you can search text messages, right? You could search for a keyword. Oh, the phone went the other direction.
Okay, so, all right, so council, you both looked at this, correct?
Yes,
Yes.
All right, so. Okay, starting Tuesday, July 9th, 10:59 PM, from Mr. Branson. Sorry for the late text, but with the possible heavy rain, make sure you let me know if you're getting wet tonight and tomorrow. Miss Collins, would that be in my room or the basement? Sorry if me just getting home woke either of you. Mr. Branson, basement, we have never had a flood, but it's supposed to get nasty. You didn't wake me, I'm on a call for work, so up all night, and I just realized wording and apologize. Ms. Collins, never apologize. It shows you're a great landlord on top of things and want the best. Also don't want the worst in long term. I will watch out. We have to do laundry anyways and was unpacking a little to get ready for Sky.
Shows you're a great landlord. Let's submit that in our case against the landlord.
Which I don't think is relevant for I don't even know who Sky is. But anyway, so it acknowledges that there's not any flooding, but since there's going to be a lot of rain, he wanted you to look for that. I don't know. But it acknowledges I don't find that there's flooding in the basement. But I still haven't heard any testimony that would support your client's motion to dismiss on number 7. Now, whether or not the monies go to whomever, that's a different story. Okay, you're saying that you didn't have room with heat. You have a room without heat and air conditioning. Upstairs front room.
Again, I'm looking to call a witness and.
As it relates to the heat and air conditioning in the room?
Yes, as it relates to everything.
No, I'm asking specifically about the heat and air conditioning.
Also specifically that, yes.
Okay.
I've requested a continuance because I need to be able to, like I say, lay a foundation and call Ms. Collins. I'd like to call Mr. Branson. I'm trying to subpoena and call someone from the city.
Okay, so council, I've heard your request for a continuance and I'm not likely to grant that right now because this is now the 4th date that the parties have been back. This is the 3rd date that you've been here.
No.
Didn't you start on the 14th?
No.
Weren't you here on the 14th?
No.
Oh, no, you were not.
You want to hear from the swingers date?
I'm sorry. So which witness are you intending to call regarding the heat and air conditioning in the upstairs front bedroom?
I'm intending to call Mr. Branson and Ms. Collins.
Okay, well, I'm call them right now. They've been sworn in under oath.
Okay, but the problem is that I need time to deal with the exhibits. I still need a continuance, Your Honor. It's my 2nd time here. This is in less than a week. So I'm sorry that the plaintiff's procedural history is in whatever state it's in. However, again, whether, you've explained to me it's not a motion for summary disposition, but I can't emphasize enough that number 7 is just not true because it's not in compliance with local laws. That's what I was intending to discuss today. And of course, if, we need to pull the evidence to talk about that, that's fine. But the problem is I still need to be able to give my client a fair trial. And I don't feel I can do that under these circumstances. It would be different if I had been before you for a month, Your Honor. I would understand.
The compliance portion regards applicable state and local health and safety laws. Okay, the ordinance that Mr. Branson may or may not be in compliance with based upon the certificate of compliance or certificate of occupancy is an ordinance, not necessarily something that falls under the health and safety laws. So the issues that we have to, so I think at this point, I'm going to dismiss the motion. I'm going to deny the motion to dismiss because the court doesn't find that the defendant was not being, or the plaintiff was not being truthful when he declared that the residential property was kept fit for the use intended, has been kept in reasonable repair. Reasonable repair doesn't mean 100% in repair during the term of the lease or license and is in compliance with applicable state and local health and safety laws. Okay, there hasn't been any condemnation notice put on the home. there hasn't been any other citations that Mr. Branson has received that would call into question the health and safety laws as relates to this property. Now, the other issues I indicated that I was going to address regarding the escrow, where the money goes, okay? Are you prepared for that?
No, I'm not. I was prepared to come here and discuss a motion to dismiss based on the fact that there's no certificate of compliance. You know, it's pretty straightforward in a lot of other circumstances.
What's pretty straightforward, counsel?
Like if you're in a locality and they check that there's no certificate of compliance, then it's illegal to rent the property. So the complaint has to be dismissed if it's for non-payment of rent. It has to be treated like someone's squatting.
What?
You have to issue a 30-day notice.
Look at
to
the
quit.
judge's face.
You have to proceed like this. You can't proceed, and she's paid, so there's
Where's the law that supports that?
Okay.
Where's the law that supports that if Mr. Branson does not have a certificate of occupancy or certificate of compliance, that the tenant then has to be treated as a squatter?
That's not what I mean, Your Honor. What I mean is she's been sued for non-payment of rent. She's all paid up in rent. But if there is an issue where there's not a certificate of compliance, you hold a different opinion, but I've stated over and over again that 7 cannot be complied with. That's why a lot of cities are putting into their ordinances specifically that these an eviction cannot be, a judgment of eviction cannot be issued against a defendant in these cases because of that.
But MCL 125.530 indicates an action can be maintained. So if the state law and the local ordinance are in conflict, which one prevails?
It's silent in the local ordinance, but it does say you cannot rent without a certificate of compliance. It's still an illegal occupancy.
So then that is an issue that Mr. Branson will have to deal with the city of Wyandotte if they choose to issue anything regarding him renting property without a certificate of compliance.
Right.
So how does that fall under violation of a health and safety law?
Okay. I'm a little pulled in 2 different directions. 1 second.
Your Honor, while she's, may I respond to her arguments, Your Honor? If it would
just for a moment.
Thank you.
Give her a minute. I'd like to hear the answer.
I guess I need clarification. Is it the court's contention that ordinances cannot be health and safety laws?
I didn't say that they could not be health and safety laws. What I'm asking is what is the authority that states that the ordinance, right, and not complying with the ordinance is a violation of the health and safety law? That is what I asked.
There's not an assumption when there's a law written to protect health and safety that that's what it's for.
You're telling me that a certificate of compliance is to protect health and safety?
Absolutely.
Okay, where's the connection for that?
Because a certificate of compliance, a city goes in and does an inspection. A certificate of compliance in this case in particular, because obviously you can have commercial ones, is for residential use. That's to make sure that the tenant is safe and it's up to city code. That is the point. It is absolutely to protect the health and safety. It's absolutely pertinent. It's a health and safety law.
Where is the law that states that the ordinances of a locality that addresses rental properties falls under the health and safety laws of the state of Michigan?
I would like a 5-minute recess to locate a case.
Okay.
Thank you.
Well, we're having a recess. We'll go off the record. I'm gonna have you go out into the lobby though, so I can, so my courthouse can have a few minutes of the meeting.
Hello, Your Honor.
Oh, yes.
Thank you.
Everyone go out in the lobby. 5-minute break. Start your timer. Start a timer for 5 minutes. Okay. What's the chirping? The chirping.
It's 39 degrees outside.
Yes, it is 39 degrees outside. Thank you. The chirping is the crickets for when she tries to answer the judge's question and does not have one. The judge is going to refill that mug, possibly with something stronger. Now that everyone's out of the courtroom, the bailiff gets a brief break as well, but please don't fight in the lobby while the judge is gone. She put everyone on a timeout, 5 minutes. Okay, Here's the thing. I was saying this before. She might, by she, I mean, I'm talking about the defendant. Let me run back to my usual place, because if I'm not there, I can't cope with things. Let's go back here. Run to A. Zoom. Wow, that was fun. She might have a legitimate excuse. Oh, we've got a call. Hang on. Hello? 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 Oh, I tried. It was a spam call. It was perfect timing, too. She might have a legitimate case. This guy might be sort of a slumlord and more than a landlord. But the evidence that we're seeing every time she tries to make an accusation says otherwise. Yeah, he might have an old property. It might be run down. It might need a lot of repairs. But every time she complains about a repair, he seems to be acting on it, and very quickly. She's like, bugs in the bathtub. He sends an exterminator. And let me know, fix it. Thank you. That's great. You're the best landlord ever. Love you. Don't apologize for anything. Then it smells musty down here. I'll send over a dehumidifier. We'll get that going. It's a big rainstorm comes, and he's like, hey, we've never had a problem before, but if there is one, let me know. He seems like a great landlord. He seems great. And she does not seem quite like the same caliber of renter, which I guess you could call me a landlord as well, because we have an Airbnb. It makes me nervous, right? We've had amazing renters every single time. The one we have right now, he's probably got another, 2 months or so on his contract. It's incredible. It's just great, wonderful. Calls us up and says, hey, I've got a question about this. We're like, sure, no problem. Done. He's like, hey, I'd like to bring a bunch of people over, in our agreement. That's what it says. Calls, no problem. It's all good. So we love it. I hope we don't ever get a bad one. She doesn't want to pay rent. But here's the thing. Her lawyer says we are caught up on rent. So she's paid everything either to the landlord or to the court to be held in escrow. So the money's there. From the payment side, the court won't look at it and say, oh, you're behind on your rent, because the court is holding that money in escrow. She just wants to say now, because of the landlord's, all these problems we had, the health, I've been in the hospital because of the mold. I caused a vitamin deficiency, and so now my body can't reproduce. Those are her words. I'm not going to delve into that very far. Because of that, I'd like to not pay that rent. I'd like all that escrow money to come back to me, and it's significant. I think we're looking 6 months or so. So thousands of dollars, $1,500 a month. Escrow is what they're fighting about right now. The motion to dismiss that she raised with all the pictures, I think, has been thrown out. Tequila Mockingbird, I don't think I'm a slumlord. We completely renovated that entire place, and brand new everything. Water heater, air conditioner, like the heating and cooling, new plumbing, new electrical, upgraded electrical to everything's up to code. Everything is inspected. I have a certificate of occupancy. Everything is permitted. We've done everything we possibly can. It's painted nice. It's decorated. It's got nice little porch lights and welcome mats and laid out with fully furnished with not just with furniture, but with all the fixings and the utensils and everything. I think we're pretty good. We have an ironing board. I guess that's not big, but I never use them, so I think that's a big thing. Brand new bugs in the shower. No bugs in the shower. So I've seen the Airbnb, and definitely not a slumlord. Thank you. It's a nice one. All new, no bidet. There's where I fall short, Tisha. I have not. Oh, that's the timer. You're due back in court. That's my duck. Hear that? We have the duck timer going off. So 5 minutes has passed. Please, everyone, come back into court. This is going to be great. No duvets, no bidets. And I think, and we charge less in rent than this lady pays. Have the same setup. Let me know when your son moves in for free rent. We have not even had we had some neighbors who said, "Hey, we might be interested in renting out your unit because we've got family members come in. We don't have room to let them stay in our house over the holidays." But we've been booked up. We have not even had available space to let friends stay. A sofa and no couch. No, we've got the couch. We've got matching chair. Desks, credenzas. We've got spare blankets. We do have duvets. As a matter, we do have duvets. We've got all the bedding sheets and spare sheets for both bedrooms. Washer and dryer. I don't think I'm a slumlord. Let's see. The duck alarms reminds me to drink water. I'm one bottle behind right now. Usually have another bottle consumed by this point. It is awesome. I think the reason why we're booked up on our rental is because we advertise to traveling nurses specifically. There's websites out there that are tailored for, or that traveling nurses basically target, and they know that's where they can go to find a unit that will have everything they need. And they like their review system, and the payment methods work well with how traveling nurses get paid and all that. And so because of that, we get just booked up really quickly. We almost rented to Mr. Beast. I kid you not. I almost rented my Airbnb to Mr. Beast. He had a production company that was flying people in from California, and they just needed space, tons of space, because they were flying in all these cameras. When he does a big thing like he does, it takes a ton of crews to put, crew members to put that together, and they needed space. But at the last minute, the guy who was doing the booking found out that his company wouldn't allow him to rent Airbnbs. They had to be hotels. So they ended up putting people up in hotels all over the area and shuttling them much further than it would have been from my place. But forever reminded of your Airbnb with a hot tub that had no hot. Yes, there was no tub. Well, it was a hot tub, but it was waterless. Was the problem. Let's see. Mr. Opatorso, it would have been camera crews and editors that we had brought in, flown in from, I think, California was where they're coming. They were actually in the air when we got contacted the first time. They were flying to North Carolina when they said we'd like to book the place. We bent over backwards to comply with him, and then at the last minute, he said, "I have to cancel." But since then, we've been booked full of nurses. Yeah, the nurses are fantastic. I think we've had one that brought a pet for the weekend, which is unless it's a service animal, we don't allow pets for the reason that our family is highly allergic. Our allergies are very, very high. That's why we don't have an indoor cat. It has to stay outside. But obviously, if they have a service animal, that would be allowed because that's the law. We would just take care of that. Wait a second. Painting, and I heard you say a hot tub with no water. Evangeline Light, that was the Airbnb we rented when we were on our trip out to the Corey Richens hearings we went to and some of the other stuff last summer. And we rented an Airbnb. I chose it because of the hot tub. And it's like all the pictures, it literally in the description, it's like great location, fantastic house with hot tub. We were hot tubless. And the entire time we were there for about a month, they could not get the hot tub working. They never even sent somebody out. It's just a tub. It was just full of rainwater because they put a leaky tarp over the top of it and just left it. But there was no electrical to it. There was nothing. Like, I could fill it up. I mean, I could steal the neighbor's hose and fill it up. But I didn't want to be responsible that way. BFF is a traveling nurse, and she loves it. The people that talked us into creating an Airbnb on converting our detached garage into an Airbnb. She is a traveling nurse. Right now, she's in, I think, Alaska, like way up, Like, think Arctic Circle. That's where she is. She's way, way up there. And absolutely loves it as well. Just phenomenal. A traveling nurse, it's a nurse that's sort of hired temporarily by hospitals. And hospitals a lot of times will constantly be hiring traveling nurses because of, they can give them all the crappy work, first of all, because they're not going to be there very long. But it does cost a lot of money, and those nurses make bank. AZDCS Oversight Group gifted a membership. Thank you very much. Were you renting to traveling nurses during COVID? No, we just got this done. Man, I think we started the remodel sort of on the tail end of everything. Took about 8 months to remodel everything. Oh, wow, work in Dubai. It's incredible. They are usually 90-day contracts, which works great for renting. It's cool. All right. Where is everybody? Are they still... We had a 5-minute break. I think I'm going to make a prediction here. I predict that the defendant's lawyer is going to, if she doesn't get her way for a continuance, is going to, how do I say this? Have a medical emergency of some sort that will require the court to allow her to get a break. It's supposed to just be a 5-minute break, and that was 10 minutes ago. The lawyer in blue didn't think she had to come back. She didn't understand. Well, they left their stuff on the table, so I think everybody has to come back in. I see items on both tables. It'll be another panic attack or a temper tantrum, which I think might look the same with this particular attorney. The lady is the lady who's closest to the camera in the top picture above me here. She is the defendant, and the plaintiff up on the top is the guy who sort of seated off to the side, and then he has his attorneys next to him. One attorney is about to retire and wants to just be a chicken farmer, and then he's brought on this other attorney, this new lady who's made a first appearance today in this case. The chicken farmer was accused in previous hearings, I think 2 hearings ago, or maybe 3, was accused of being a swinger and going to parties with the judge. That was a fun moment. That was interesting. But apparently that was not the case. But that was where they went. That's where they went because clearly the judge is biased in this case. And that bias is in favor of the plaintiff, and so they must be swingers together. There you go. That logic should be clear as mud. Does he have bodyguards today? They both lawyers have sort of introduced some drama that way. Saying, I don't feel safe around the other person. I need a bailiff to walk me out to my car. I need them to leave first and have a break. We need somebody in the middle that can talk, because I won't talk to the other person. It's been good. What are they arguing about? Rent money. The lady closest to the camera in the top picture, she rents a place from the guy on the top. The guy is the landlord. The lady is the renter. They apparently, I just found this today. Apparently, they rent, it's like a duplex, and he's in one half of the building and she's in the other. So he's right next door. So, I mean, they hear each other through the walls, which must be crazy because when court's over, they both go to the same home. They both go home. Who made the accusation? It came from the defense table. We've also had the last hearing, a friend, because the defendant wasn't able to be there because she had to work or something. She sent a friend to court, and the friend was filming the proceedings from the gallery with her phone and got in a fight with the bailiffs when the judge ordered the bailiff to take the phone, and she didn't want to surrender her phone. And eventually the judge conceded and let her take her phone and went out and put it out in the car. This has been a circus from the very beginning. This specific motion to have the escrow money returned to the renter. She's the plaintiff for this hearing. I thought it was that the motion to dismiss and then have it returned to her that got denied, right? So we're back on the major motion. Now she's trying to slip by paying or leaving by using the squatting loophole. There are some courts that are just, Lois, that are just boring, in that they are so effective and they're run so tightly and so properly that they're boring. I'm not a big fan of those courts because not every court case is the same, right? My speeding ticket might have different facts surrounding it than somebody else's. And if you just treat everything with a rubber stamp, where are you speeding? Bam, done. I like the courts that allow for a little variance where they say, how would you like to plead? Is it not guilty, guilty, or guilty with an explanation? I like that explanation part. I want that little part where it's like, Judge, I do want you to see the whole picture. Okay, and I realize we're saying this on the heels of a trial where the jury did not hear what a lot of people feel is the whole picture. But I think the judge has to be able to consider the immediate reason why something was done. In this particular case in the trial last week, the judge considered that and said, yep, and that's not coming in. Let's see. I would look up Swinger, if you want this. Look up Swinger on Law Talk with Mike. His channel has covered these hearings very well, and he has the whole thing. I've missed some of them. What was the West Virginia lawyer with all the drama? Oh, I don't remember. I have a terrible memory. I'd have to see a picture. I'm a very visual memory that way. We're looking at starting a trial that on Monday that is was it Cremo? Is that the name? Cremo? If everything works out right. Is the parade shooter guy? Highland Park? I think that's where we're going. But I think it's just jury selection on Monday, so that won't be shown. So we'll have to see how long it takes. We also have another hearing that we want to watch today, as soon as this one ends, with Judge Stephanie Boyd. It's a little older, but looks like a goodie. What's your impression of Judge Frank Caprio of Rhode Island? Is he the judge that, like the kind grandpa that? It's a little bit like, it's got a tiny bit of Jerry Springer, and a little bit of Judge Judy, and then a lot of just grandpa judge mixed together. I like him. Watching some of his court cases, it looks like some of it's contrived, like it's been set up, almost like a TV show. You've been in front of him. He's retired now. Is it a TV show now? Does he do a TV show? Is that what we're watching? Am I thinking it's real court? This current case live? Yeah, we're looking right now live at the bailiff. What's he doing? Bailiff, you're on camera. What? Whoa. Just taking a peek around the tables. What are you looking for? Gonna go over here. so we can see what's happening. There's no safe place for me to be in this courtroom unless I'm really small. That's probably a little too small. I'll be down here in the judge's corner. Looks like they're still arguing it out in the hallway. Someone might have sent him in to get paper or a phone or a jump drive or something like that. This is probably the most action these bailiffs have seen in a long time with this case. Here's the judge. All right, bring him in. She's got the big mug. She upgraded from the little cup she had this morning. Apparently 12 ounces is not enough. We've gone up, what is that, a 24 ounce mug? Okay, bring him in. Bring him in. She's like, well, I'll just sign these bench warrants while we wait. Click, click. Let's see, bench warrant. Okay, here we go. Parties are coming in. Found it. It's like, this is what I needed right here. Couldn't you find it? He finds it. That's like a 40 ounce. She's got a 40. The mega pint. She's got the mega pint. That's a full-size TikTok Mom Stanley Cup. Those are the expensive ones. Person in Lawyer Lee's channel stated she has a cousin who was on a rose petal jury. Lee asked her to see if she wants to come on and talk about it. Okay, we've got a scam call. Hang on. Hello? Hang on, I can't hear you. Can you hear me now? Hello?
Oh, I'm speaking with Dwayne.
Okay.
Oh, good afternoon, sir. This is Jacob calling you from your choice getaway. How are you doing?
I'm good.
Oh, great, sir. So I'm calling you about a large amount of travel credit you have on file. I see the activation fees recovered you. Just never booked it's on travel. We don't want to see you lose the credit or the vacation themselves. And I know you still see yourself traveling in the future, right?
Mm-hmm.
All right, sir. So we are starting you off with 4 days, 3 nights, resort stay in Vegas, either on up the strip. You also have 4 days, 3 nights, resort stay in Orlando, within minutes from Alden Park. So additionally, you can enjoy an 8 days, 7 nights, all-exclusive Flix cruise with Carnival, Royal Caribbean or Virginian Cruise Lines. Now, all I see are remaining on the original booking and processing fees. I know that I can do something really special for you. Give me a moment to pull up your full account and let me see what this is for you. So can you please hold the line for a moment while I'm get more information on that, okay?
Can you waive my fees for me?
I'm sorry?
Can you waive my fees for me? If I take like a inner cruise, like have no windows or like an inside cabin.
Sir, just give me a moment, sir.
Okay. He hung up on me. He hung up on me. He just Googled, what does waive your fees mean? And he's like, oh, never mind. Never mind. All right. Like, apparently they can't waive your fees. Look at the judge's face. She's quite expressive. Okay, what are we waiting for? Bring him in. Bring him in, Judge. Here we go. We're back on the record.
Out there at the front door, with Ayden and Mark.
Okay. Consolation, I had just like had part of one of those muffins that are in the kitchen. So.
Muffins?
I wasn't hungry until I started smelling all that.
I wasn't either. When I saw the muffin, I was like, oh no, it doesn't necessarily go with, I don't think there's much protein there, but. Okay.
Put bacon on a muffin though. That's good.
Okay, let's go back on the record in the matter of Branson versus Collins. 24-02269, an appearance for the plaintiff again, please.
Good morning, or good afternoon, Your Honor. Amy DeCray on behalf of the plaintiff, Mr. Branson.
Okay, thank you.
I'll leave that likewise, Your Honor.
Okay, Mr. Branson.
William Branson, Your Honor.
Thank you, counsel.
Good afternoon, this is Megan Duckle on behalf of the defendant, Heather Collins.
Okay, thank you. Okay, and just so you know, there is an individual sitting in the court. She had scheduled a meeting to meet with me on some mental health something or other, I think, as part of her research class. She's on mock trial team in the 33rd District Court, so she's not here at any point regarding anything with this case. I just wanted to state that on record. Okay. All right, so counsel, I did give you an opportunity to want to look up some case law.
Thank you for that. I clearly need to brush up on what I learned in law school. It's the Home Rule City Act. So under the Home Rule City Act, and that's the State of Michigan Act, section 117.3 under mandatory charter provisions.
I'm sorry, it's MCL 117.3?
No, that's the section. Let me look up what the Home Rule City Act citation actually is. Okay, so it is MCL. No, that is correct. It's 117.3. And under the act, if you go under 117.3 and go down to section J, it states the public peace and health and for the safety of persons and property. In providing for the public peace, health, and safety, a city may expend funds or enter into contracts with a private organization, the federal or state government, a county, village, or township, or another city for services considered necessary by the legislative body. Public peace, health, and safety services may include the operation of child guidance and community. Okay, it kind of goes on, it's contextual. The purpose of this act, Your Honor, is to state that the body corporate, which would be the city in this case, they are allowed to enact laws in the form of ordinances that protect the public peace, health, safety, and welfare, and carry out the enforcement of that. Now, in terms of a case, I can give you the federal side, or would you like the Michigan citation? Does it matter?
Well, hold on a moment. So before we get to the case, which the case is going to indicate how the laws apply, you're relying on MCL 117.3 to be the prevailing statute as to show that the not having the proper rental certificate is a violation of the health and safety laws.
Correct. This is an enabling statute. So it's a specific directive by the state of Michigan that what the city is doing is it's enacting laws that are for the purpose of health, safety, and welfare of its citizens, and they're responsible for enforcing those laws as well.
Okay, so under J, which is what you referenced, the public peace and health and for the safety of persons and property, in providing, well, actually, it talks about each city charter shall provide for all of the following. and, J is the public peace and health and for the safety of persons and property. Is it, what's your phone doing?
They were on for the text messages.
No, there's only one that should be on, not they. Only one should be on because only one is what we've been using for text
I text
messages.
messaged my boss to let her know I'm still not coming in yet.
Okay.
I had to work today.
You turned it off?
Yeah, I just turned it on.
Subsection.
Hold on, Council. The public peace and health and for the safety of persons and property, providing for the public peace, health, and safety. A city may expend funds or enter into contracts with a private organization, federal or state government, county, village, or township, or another city for services considered necessary by the legislative body. Public peace, health, and safety services may include the operation of child guidance and community mental health clinics, the prevention, counseling, and treatment of developmental disabilities, the prevention of drug abuse, and the counseling and treatment of drug abusers. I'm not seeing anything in here
About rental.
how
Rental
certifying
agreements.
rental homes falls under health and safety.
Absolutely, Your Honor. There's actually several mentions of health and safety and welfare within this statute. That is merely the first.
But it still doesn't apply to rentals.
Please, but the case is certainly informative.
It doesn't apply, but the case is informative. Ignore the fact that it
Your
doesn't.
Honor, may I make a statutory construction argument?
Just one moment.
Thank you.
Okay. If you go down to section 117.35, it does reference the health and safety of persons living adjacent to land that's been condemned.
Okay, hold on. 0.35.
Okay, so that's
Yes.
also not the case.
And then I'd like to direct the court's attention to the case.
Okay, what's the name of the case? Well, I'm trying to get to 0.35. What's the name of the case?
It's called Sabab versus City of Dearborn.
Okay,
Dearborn, Michigan.
SABBAGH, AUGH?
Yep,
Okay, is this a published opinion?
it is.
Okay, what's the citation, please?
384, Mish, 510, 1971.
Goes back a bit, but okay. 384, 1971, something like that. Every time I watch these little mini trials, I get the urge to take the bar exam. It's like it must
So
not be that
this
hard.
case is actually particular.
Hold Before I get to the case, I'm going to give Attorney Ayden an opportunity to respond to the statutory portion.
Thank you, Your Honor. While I don't disagree with Sister Counsel that this is an enabling statute, this statute was intended by the state of Michigan to allow for the division of large parcels of land to become cities, states, or cities, townships, counties, and things like that. And it is a provision that allows them to enact statutes or to act ordinances and codes and then thereby enforce their codes in manners that include, spending money to do it and also to engage in contracts. But you're absolutely right on point when you pointed out to Sister Counsel that nothing in this statute indicates that this specific ordinance was enacted by this municipality, a quasi-legislative body, because a municipal ordinance is enacted by a quasi-legislative body, quasi-legislative body was intended to be for the general welfare. So this statute says, yes, cities can do these things. They have the ability to organize themselves and to create a government and to run their government and to collect and expend funds for the running of their government. But nothing in this statute is relatively on point to determine whether or not the CFO statute or ordinance is from is part of a health and safety or health and welfare was enacted for health and welfare purposes. And moreover, what you said earlier is actually right on point. When you question Sister Counsel about the interplay between the powers that be here, the state ordinance, which we know is, which we've cited many, many times, is 125.530, and the city ordinance. When there's an interplay between a state ordinance that's directly on point in something, the municipality is not at will. And when Sister Council talks about this case, it's actually proven in this case that the city is not at will to abrogate that statute. The statute set forth the remedy. The statute did not set a private right in the defendant or in a tenant in this case. So while this statute said, yes, the municipality can do that, nothing in this statute says that that's what this municipality did, or that that specific ordinance, the C of O ordinance, falls within the scope of health and safety of this community, Your Honor.
Okay.
Okay, Judge, let her have it.
So just one moment.
Case law does not apply, but please review the relevant
Your Honor, I'm
case.
sorry if you're sick of hearing it, but I'm not sure how much longer we have to go. I again need to request a continuance. I wasn't anticipating being on. I have other important business matters that I'm missing.
Okay, Council, when we scheduled this date, nobody said anything about having any time limitations, or else I would have addressed that at that time.
I didn't think it was reasonable that this would be this long.
Class is not dismissed.
So are you stating that it's unreasonable that it's going this long?
Frankly, with the situation in terms of the clear violation where cities are responsible for the public safety, health, and welfare, and that involves having proper licensure to collect rent under a lease agreement in a residential property, yes, I think that it should again be dismissed on that basis.
Okay, now, Council, you're making many leaps without having any connections to get you to the other side. Because even under the Michigan Occupational Safety and Health Act, Act 154 of 1974, which is in the chapter 408 chapters, I have yet to see anything that would tell this court that a rental certificate falls under the Safety and Health Act, whether it's the Occupational Safety and Health Act, whether it's any health act, anything, any of the chapters within the statutes. I have not seen that connection. I understand your thought process that because a house may not have a rental certificate, that there in and of itself is enough to say that there is a violation of health and safety laws. There's not a connection for that, to show that. The issue regarding whether or not Mr. Branson had a valid rental certificate is an issue that he's going to have to address with the city of Wyandotte if they so choose to pursue that. As it relates to your client and her obligation to pay rent without having a valid certificate of rental, your client isn't even allowed to withhold rent without depositing it into an escrow account. So clearly there is a lot of consideration for these types of situations because there's an entire statute on it in MCL 125.530. And nothing in here indicates that this would rise to the level of violating health and safety law. Okay, clearly municipalities want to make sure that there are any homes that are being rented or anything of that nature, any buildings being rented for multiple purposes, right? They want to make sure that businesses are properly registered. They want to make sure that rental homes are properly registered. They want to make sure they know who owns what property. They want to make sure that if somebody is renting something that things are up to code or what have you, okay? So that doesn't necessarily mean that falls under health and safety law because I haven't even seen anything in the statutes because these rental certificates, I believe, are good for 5 years. So within those 5 years, there's not re-inspections to make sure that the homes are still habitable and still complying with health and safety laws. So I don't find that not having a certificate of rental, a rental certificate falls under the health and safety laws. So you can respectfully disagree with me, and you've stated that you disagree with me, you don't find that it's reasonable, and that's your prerogative, counsel. If you feel as though I've gotten it wrong, you can certainly file an appeal. But this court does not find that there is a basis to dismiss this action on pursuant to paragraph 7. Because paragraph 7 states
The judge just wants to get this done with today.
that
She's over
the
this.
home has to be kept in, that it's been kept fit for the use intended, which there hasn't been any testimony that's been not kept for use intended, which was a rental property, which is why the allegation that he doesn't have a rental certificate has been at the forefront, has been kept in reasonable repair during the term of the lease. Okay, I've heard some mention regarding an outlet, possible mold, but there's not anything that was put forth prior to this matter having already occurred. And it says reasonable repair, doesn't say 100% compliant without any repairs needed. And the court, and it also says it is in compliance with the applicable state and local health and safety laws. So this court's interpretation of that provision is the home has not been condemned. There have not been repeated citations issued to Mr. Branson regarding the violation of any of the codes or property maintenance or anything of that nature. So for those reasons, I find that the home is in compliance with applicable state and local health and safety laws as far as that goes. Mr. Branson will have to deal with the city of Wyandotte if they so choose to proceed. However, if they do, with not having a rental certificate while he was renting the property and collecting rent. The court will also note that Mr. Branson, there's a check that was written at the beginning of November for an inspection. So we're talking, he moved in the month of June, about a little over 5 months of not having a rental certificate.
She counted on her
Not having
fingers.
a pending one or whatever prior to requesting an inspection. Now, I don't know what's happened with any of those communications. I'm not sure about any of that. But what was submitted in the exhibit that I reviewed last night was that there was an email and a receipt, or not an I think, there was a receipt. And I think that there's also a letter included in one of these exhibits regarding that request. So
She's still
I'm denying the
researching.
motion to dismiss. I'm not denying your client or yourself, counsel, a fair opportunity to present evidence. I do not find a connection with the ordinance requiring a rental certificate to fall under state and local health and safety laws. So that's the ruling of the court regarding the dismissal. Motion to dismiss. So that's denied.
So now where do we
I
go
don't
back?
believe that there's any specific testimony that would alter this court's ruling as it relates to the motion to dismiss, because in this court's opinion, it's a legal analysis as to whether or not the property is in compliance with applicable state and local health and safety laws. But I went through the exhibits that were put forth and
A lot of
the
shuffling
issues that
going
your
on.
client raised in her written motion
A Velcro
regarding
binder.
the flooding and the bugs, because that could potentially rise to that level. But based upon the testimony that I heard and the review of the messages that I reviewed, that does not seem to be the case. It appears as though Mr. Branson, when something was brought to his attention, treated it as it needed to be treated, or responded as it needed to be responded to. Now, as it relates to the issue of the June rent, let me do this. We have the June rent. We also have the security deposit, because I believe that your client, which I didn't specify this previously, I didn't make a note of it, but I recall that your client, that there was discussion regarding the security deposit, which I think, as we all know, that you can't do anything with that until after Ms. Collins moves out
Just a
to determine what, I'm sorry, what?
I'm gonna stay until the end of my lease.
No, that is not what this court ordered.
This is, if you're gonna say that this is habitable and I've been paying my rent the entire time.
First of all, you just interrupted the court as I'm talking. But as I was saying, the court, as we all know, we cannot make a determination regarding the security deposit until after Ms. Collins relocates to see if there's any deductions or what have you. Now, Ms. Collins, you stated yourself that you were moving out. You did not want to stay there.
No.
You did. You stated that on February 7th or 14th.
No. You took my words and you twisted it, Your Honor.
I did,
Yes,
right?
yes, you did.
Okay, so what is it you said, ma'am?
Your Honor, this right now is the only place I can stay.
No.
Right now, I just found out my
That's
cancer is
not what you
bad.
said. No, that's not what you said. What is it you said?
I am 100% paid up to rent. This is an eviction. If I did not pay my rent,
Ma'am.
I was gonna have to leave. I'm
Ma'am.
staying until my lease is up.
Ma'am.
I
what is
appeal
it-
this.
Excuse me.
I'm appealing this.
What is it that you said?
Then I'm gonna stay here.
No.
Yes, I did. I said that day that if you're gonna make me pay, I was going to stay. That's exactly what I said that day.
I asked you if you.
That's exactly what I said.
I asked you if you wanted to keep living there, and you said, no, you don't. You said, I will gladly move out.
No, I did not.
Yes, you did,
No, I
because
did
then
not.
we got into the discussion as
No.
to the escrow money and who gets the escrow money. Because you said that I need my money back so I can go find a place to live.
The judge
That
is
is
going to give
how
her
that
another place to
conversation
stay in
went.
just a minute.
So. The other issue that we have to address is the escrow money. Any other issues that we need to address?
Not at this time for our plaintiff, Your Honor.
Are there any other issues that we need to address, counsel?
No.
Just those issues?
Yes.
The June rent, oh no, the utilities, we have utilities that we have to address.
Your Honor, is there any way we could resume at another time with the rest of this?
I'm going to pick another date, I just want to make sure we're all on the same page.
I'm just trying to get somewhere. Okay, yes, the utilities.
Okay, anything else?
I don't think so.
I need a timely manner to figure things out.
Yeah, I'm not telling you have to leave tomorrow.
Thank you.
I'm not saying that at all. Because I also recall that you say that you've been looking for places to move. So to tell me that I took your words and twisted them, ma'am, is not accurate. Okay.
Your Honor, I
So-
think you also requested that she provide to you the names and addresses and phone
did.
numbers of the people that she's contacted.
I will not get that to the court.
I did request that, ma'am, because you stated that you needed a certain amount of money to move out. So I was trying to facilitate some sort of resolution between the parties. That is why I asked you for a list of where and the cost that it would take for you to move there.
I'm looking at the cost right now is roughly between $4,000 to $5,000 to
Okay,
move.
that's why I asked you for something in writing to present to the court. Because I have some credibility concerns based upon what's been presented to me and only wanting to give me partial information.
It cost me $5,000 to move here into this
Yeah.
place.
So I did ask for you to submit that information to the court as well.
I will have that next time in front of you, Your Honor. I thought it was unsafe because on YouTube I've been harassed.
What?
With your YouTube, I have been getting emails, I've been getting text messages because you put all my information out there.
I don't put your information out there, ma'am. Okay, so we live stream, right? Courts are live streaming.
I did not know that at that time.
Ma'am, it's posted all over. The sign's there. There's a sign out in the lobby. There's a sign on our website. There's plenty of notice that we live stream. We do not, and then we take it down after each of the,
I would have never put my email to you. I would have never given you my email. I would have asked you to do that in private. I would have never given it to you.
I don't remember giving me your email.
You had me give it to you. And you also had me give you my place of employment. And I would have never given you either of those. I would have never given you those on
Okay, I don't recall having you
think we
provide
saw
an
that.
email address.
Yes, you did.
Zoom. Not going to be hearing, but okay, and I apologize if I did. I don't recall that.
And getting harassed many times at work.
At work?
Work and in my email, yes.
Okay.
Because of that.
Okay,
That's a
well,
crime.
ma'am, I am unsure how to rectify that issue.
File a complaint.
I mean, I would hope that people wouldn't be contacting you. It's not appropriate,
Nobody should do that.
in my opinion. So, we're going to have everybody return, we're gonna pick a date. These are the issues that we are going to address.
And nothing else.
Everybody, I'm expecting to be prepared. I'm also expecting that there is going to be productive communication, conversation, exchange of information, whole information between council.
Hello.
And Ms. Dekwala, I did, and Ms. Council Amy and Mr. Dagger, I did review all of the communications that the court was CC'd
Today,
on regarding, regarding the request for utilities, the refusal to speak to Ms. Kennedy, or respond to Ms. Kennedy because it's unauthorized practice of law. Counsel, she is a paralegal, apparently under the supervision of the attorneys, so there can be communication with that. So Ms. Kennedy, I apologize that we've messed up your vacation day today and we haven't needed the body cam video. I don't know if we'll need it next time. I guess just have it ready to go in the event that we have to talk about it. I don't know. But the court is, let's pick the date.
Your Honor?
Yes.
I was attempting to discuss the utilities issue with Ms. Kennedy outside as per your directive last time.
Okay.
And she would not go talk to Mr. Ali Dagger about what I was saying. That's why I said I needed to speak with him. She would not go and communicate what I was speaking.
I'm talking about the email that went.
Right. But it's just a little bit harassing to me, honestly. That's the problem.
Your Honor, the real issue is that there was an email sent out where we asked Ms. Deklala for information. It was that email. Ms. Kennedy followed up and said, hey, we needed these things from you. Ms. Deklala responded to that email with abject vitriol towards Ms. Kennedy, telling her that she's, like, go get your boss. Like, you're not practiced to law. And then I responded. And
Right,
I said,
I reviewed all of
yeah,
this,
and
yes.
I need this information. And she told me, go get Ali. Like,
I didn't know who you were.
I had a notice of appearance on file, ma'am.
Okay, well, I hadn't seen it.
You were emailed it to my man.
Please stop.
You were emailed my.
I am exhibiting respect.
Okay, she's indicated
I
that
just
she
want it to
sent you.
stop. I just want to focus, I'm sorry. I just want to focus on the issues in the case.
Okay, but I will also say, if there's this much emotion between counsel, it's going to be hard to focus on the facts of the case and the resolution of the case.
Judge, the bottom line is that we just need what she promised, and that is the evidence to support whatever allegation of overpayment of utilities. It's that simple. And we've been trying since the last time we were in court to obtain that information without any success. I would like the court to designate a specific time where that information can be exchanged. We have provided all of our documentation relating to utilities, but we haven't received anything that would evidence any type of offset.
Okay,
Could we set
so, counsel, is there anything in the information that you and your client have regarding the utilities? Because I believe your client indicated she's overpaid utilities and she is entitled to a credit.
Why can we not engage in discovery requests between us?
It's a summary proceedings,
You know, well, I don't know that I don't know that discovery rules specifically apply, but the court's ordering the parties to exchange information as it relates to utilities. So if your client's indicating that she's overpaid, you can turn your phone off now, ma'am. We don't need any more text messages, so you can turn your phone off.
Looking for dates that we're gonna go to court.
Okay, okay. So your client has receipts of payments, or what is it that she has that she's indicating supports her claim for overpayment of utilities?
So she has been paying via Zelle.
Okay.
An overall rental amount, I suppose, because her landlord, the plaintiff here, texts her and tells her how much utilities she has to pay.
Okay, so here's what I need. Here's what I need. I'm going to spell it right out. I need from both parties text message communications regarding every utility bill that has been communicated. Okay, that's the first thing I need. Then I need, if all the payments are via Zelle, I need proof from your bank, the bank statements that show the Zelle. You can even print up the Zelle, whatever it is, as to where it goes. Show the deduction out of your bank. Mr. Branson will show that it was deposited into his bank. Okay, so anything else that we would need, statements, we need the utility statements. That'd be Mr. Branson would have that.
They've been provided with those, Your Honor.
I'm not saying they haven't been, I'm saying what I need to make a determination on the utilities. Okay, so that is what I need as it relates to utilities. Okay?
Thank you, Joe. When do you want us to come back here? I know, we're all excited to come back.
March 14th. March 14th at 10 a.m.
The Ides of March.
The escrow will continue, Your Honor?
Beware the Ides of March. Isn't that the 14th
Yes,
or is that the
March
17th?
14th at 10 a.m. Does everybody,
Yes.
That's fine.
Thank you for looking at that.
Which day is that on?
it's a Friday.
Your Honor, I work on Fridays.
Ma'am, I can appreciate that, but we have to get this matter resolved. I'm trying to give enough time so that there can be the information, excuse me. I'm trying to give enough time for the information to be retrieved and exchanged.
Yes, Your Honor.
And enough time, if there's any witnesses that need to be subpoenaed, to be subpoenaed.
Yes, Your Honor.
Thank you so much.
Thank you.
So, I would plan to be here for a number of hours.
Okay.
Okay?
Yes.
I don't know how many hours that is, but I plan to be here for a number of hours.
Thank you, Your Honor.
Okay?
Thank you.
All right, thank you.
Thank you, Your Honor.
Thank you. Oh, I'm sorry, hold on. The court did receive another order for inspection. And, counsel, I'm going to have you both look at it quickly, just so you can see what it is that the court's signing and that the provision regarding the third-party interference with automatic show causes, that was removed.
February 26th, between 9 and 2. Inspectors of the city of Wyandotte. Full cooperation of defendant.
Who else?
Yes, just the inspector.
Nobody else, just the inspector?
Yeah.
And me?
Yes.
Mr. Branson will not be there.
That doesn't state.
Well, I don't know if Mr. Branson is required. I don't know.
I will be there.
I would presume Mr. Branson would have to be there because he's the owner of the home.
Yes, ma'am.
And we did go over this last time.
I don't want police in my house.
Excuse me. We did go over this last time regarding whether or not Mr. Branson was able to be there or if you had to be there. And the determination after reviewing the statute is that you don't have to be there, but Mr. Branson has to be there. You obviously have the right to be there, but I'm stating that Mr. Branson would have to be there. He's the owner of the property.
I will not allow police on my property though this time, after what happened last time. I'm putting that on the record.
I don't know what happened last time. I don't know what happened last time. I haven't.
Oh, you should see the video.
They asked for my escrow account. They said that I'm in Rainbow Tenant Court and they didn't believe what was going on. It was a joke.
I'm sorry, but we have another hearing. I really have to go.
Counsel, I understand. Hold on a minute. Miss Collins, just a moment. Council, I understand that, but I also am trying to prevent what I can foresee happening on Tuesday, Wednesday. What day did we say, the 26th?
That's 26th, yeah.
That's Wednesday.
I would like for, if necessary, for the police to be there.
No.
I think the maintenance.
No, I was pushed aside and told I could not go into any room.
Absolutely not.
I have it on my security cameras as well. I was pushed aside and told I couldn't go into any rooms because I was in landlord-tenant court. I had to show them my escrow papers or they weren't gonna believe me.
Absolutely not.
Not anything you asked for to happen.
What?
Not anything that you asked for to happen. I said, no, he's supposed to take pictures that I want to. They said, this is a joke.
No. I did not state, Council, you don't have to point at me.
No, I'm sorry, I apologize.
I did not say only the pictures that you want. That is not what I said.
No, I know that.
What I said was that Mr. Branson was to take pictures of the areas that you were stating were of concern. That didn't prohibit him from taking photos of other areas of concern that he had, okay? And that was specifically brought up on the record.
He wouldn't do that. He wouldn't take any pictures I asked him to. And they said they weren't gonna make him.
Ma'am.
It was a joke, and I don't want police in my house.
Ma'am, let me just say this, okay? I cannot predict the future. I cannot predict behavior. What I will say is if a city inspector feels the need to contact the police because there may be a disturbance or there may be some concern or other,
nice, but they're not.
Excuse me, please stop interrupting me, and we're not done.
Heather.
We're not done. Please come back up here. I cannot tell the city inspector they cannot call the police. Okay? I cannot tell them that.
Bailiff blocks
So
the
what I'm
exit.
saying is,
He's gonna call them, they won't.
ma'am,
We need a ma'am
Mr.
counter.
Branson, I cannot, here's what I'm going to say. There's not a need for civil standby during the inspection. There's going to be an independent person there, the inspector. And I expect everybody to be on their most adult, appropriate behavior for the entirety of the inspection. That means not communicating in the ear of the inspector as to what they need to look at or anything of that nature, okay? The inspector knows what their job is that they have when they arrive at the home. There should not be any videotaping. There should not be any video recording. There should not be any audio recording. There should not be any communication at all, other than, hi, how you doing? Welcome to my home, whatever, something simple like that. That is it.
I promise you that, Your Honor, except for my security cameras, correct? I have security cameras out of there.
I don't know what your security cameras, would they go on when people walk in? I don't know what that is.
Okay.
I don't know what that is.
I promise I'll be exactly civil this time, 100%.
If
it's on
the
record.
city inspector feels the need to contact the police for whatever reason, that is their right. That is their prerogative. Okay? That is what I'm saying. I'm not prohibiting a third party who's not under the jurisdiction of this court from contacting the police.
Thank you.
Thank you so much. Thank you. Have a good weekend. We'll see you back on the 14th at 10 a.m. Sounds good.
Did you hear what she just said?
Did you hear what she just said?
Wait, hold on. Hold on. Please come back.
Hold on. Please come back.
Mr. Gander, what is it you just stated to my court officer?
As I stated, Your Honor, as she was leaving, she called
Who's
me.
she?
Miss Collins called me a name. Asshole.
I did not. I swear I did not. 100% I did not.
Well, ma'am, you flipped him off last week.
Okay, so you're gonna believe everything he has to say?
Ma'am, I said you flipped him off last week.
Okay, and I admitted to it, did I not?
You admitted to it.
Yes,
Okay.
and I am not admitting to this. And I admitted to things I said in the hall. I'm not gonna admit to something I didn't do. I admit to things I do.
Okay, so I'm gonna have Miss Collins and Miss DeQuala for you to please leave.
Thank
Without
you.
saying anything. Thank you, Ms. Kennedy. I'm very sorry about your vacation.
She's on the beach for she's fine.
Did you see how the name was turned her camera off so the rest of us did not have to languish behind with her beautiful screen?
This isn't my normal color works.
Thank you.
Thank you.
Thank you, I appreciate it.
I happen to have a replay machine. I have a replay machine, and we're gonna take a little look.
Yeah. When you guys go out there, she's standing right there.
Okay. It's time to bring up the replay machine. We'll take one more look. This is the case that will never end, but Judge DeSanto, get some lunch. You're going to need it. All right. It's time to bring up the replay machine. Let's see. Where are we? On. I have to bring the sound back over for you guys so you can see this and hear it. I will say I did not hear anything, but I did definitely see what looked to be an interaction between the two. Let's back up just a little bit. Okay, here we go. We're on camera 3, right? Okay. Here we go. We've got audio. Let me turn the audio off for a second as we fast forward. They're talking. They're getting ready to leave a million times over. The coats are on, and they go out. But then she says, oh, wait, that was before that. I think it was right here. Let's try this.
Thank you for that.
The escrow will continue, Your Honor?
Yes, March 14th at 10 a.m. Does everybody,
Yes.
That's fine.
Thank you for giving me that.
Which day is that on?
it's a Friday?
Your Honor, I work on Fridays.
Ma'am, I can appreciate that, but we have to get this matter resolved. I'm trying to.
We're gonna go a little farther. So right where she walks out of the court. She puts her coat on.
Thank you.
Okay, here we go.
Between 9 and 2.
Okay, they're reviewing the document. That's all good. That's all good. This never ends. It just. She walks out. She comes back in. Okay, I've got to turn the sound off so it doesn't drive you nuts. No photos, no being in the ear of the inspector, none of that. Ma'am, come back. Bailiff moves in position. They talk a little bit more. The judge's face is fantastic every time we get a freeze frame. Lots of emotions. Okay, right here. This is it. Okay. First of all, we can see the indignation on the lawyer, the male lawyer's face here. We're going to rewind just a tiny bit. Back it up, back it up, back it up, back it up. Ooh, there's the eye contact. Okay. Okay, so look in. Watch right here above my head. Ready? We're gonna play this one. Okay. It looks like she held that look there for a little bit. Right here is where she's looking at him. Let's see what we hear this time.
Have a good weekend. We'll see you back on the 14th.
Yeah, if I've ever seen anyone say the AH word from the back of their head, it was in this moment. It's like her ponytail speaks to me right here. Watch.
We'll see you back on the 14th.
There it is. It was there. It was there. Oh my goodness. Let's watch the whole thing.
Have a good weekend. We'll see you back on the 14th at 10 a.m.
Did you hear what she just said?
Did you hear what she just said? She called me. I just barely added a version of that word to the do not say list today. I felt like I heard it. That's the ponytail spoke to you as well. Yes, I didn't hear it either. The audio was not there. So this is why we have the replay machine. It's backup time. Okay, here we go.
Thank you so much.
I'm gonna go live speed, slow it down to about 80%, and watch.
Thank you. Have a good weekend. We'll see you back on the 14th at 10 a.m. Sounds good.
Did you hear what she just said?
Thank you. I've got food being delivered. It's better than DiGiorno. This is I've got yesterday's chicken noodle soup and a fresh salad. So thank you. Do I need water? I probably need a break to eat all this. There's a lot of food. All right. Where are we? Where are we on today? Look at this. Look at that. That's really cool. Thank you, Mrs. R.A. That was painful. That was painful to watch. When are we going to break for lunch, Judge? Wait, it wasn't the lady lawyer that said it, because he said she gave me the finger last week and Ponytail wasn't there last week. I thought last week Ponytail gave him the finger outside of court, right? That was because she was there in the morning, then left because she had to work or something like that. There's a lot of happenings there. I just stuck my arm in the salad. That just adds flavor. Ponytail gave him the finger last week. You're correct. Yeah. The judge is going to give her a new place to live. She's like, I don't have anywhere else to go. You're about to. You don't eat that much for lunch. Wow. It's a little plate. And a little plate. This is a bowl of soup. I mean, so there's a lot of protein and, starch and everything else in that one. The salad's light, especially this little what do they call these, cherry tomatoes? Those are good, and they're cold. All right, check what out. Evangeline says, check what out. Last week. She admitted to last week. We know what happened. She owned up to it. It's not a light lunch. It's a full lunch, which I'm excited about. I didn't have breakfast, so I'm excited for this. Should try Central America soup. It's the best. Send me a recipe. I'll see if I can convince my wife to make it. She's really good with soup. Morgan says, hi, I'm on TV. Hey, Morgan, welcome. I think it's 1:45. We needed to take a lunch break just so I can eat. This is our court hopping day. We have one other. Let's see. Is it going to be quick? Let me check with the mods really quickly. We have something from Judge Boyd, which we might watch, and I might just eat rudely during it. Let's see. It is. Okay. 57:27. Give me a second here to pull this up. All right, this is going back in the archives just a tiny bit. Judge Stephanie Boyd. Okay, so now we have to go to where? I don't know if I can do this way. I might have to pull it up on a computer. February 10th. November, December, October, September, December, February. What is the... I need a May. May 21st, 2024, Judge Stephanie Boyd. It's not liking this. Judge Stephanie Boyd, May 21, 2024. There it is. Found it. Just have to put the right words in. Okay, we're going to watch this. I think this one's a little bit shorter. And here we go. Then we'll take a lunch.
All right, who is here on Bustos? And then after Bustos, we'll take up your case. Yes, Angel Marie Bustos. Hello.
Hello.
Hi, so you know you're not dressed appropriately for court, right?
I didn't know that until I got here.
All right, so next time you appear in court, you're not allowed to wear the T-straps. If you want to wear that, I know it's hot outside. You'll need to put on a jacket or something, you understand? All right. Court is calling 2024 CR 1728, State of Texas versus Angel Marie Bustos. Could I have parties announced for the record for the state? Defense? All right, and are you Miss Bustos?
Yes.
Counsel, you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Bustos, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it?
Yes, I did.
Yeah, the
Did
judge
you review the
addressed
document
issue
entitled
of the
True Bill of
closing.
Indictment with your attorney? Did
leave
you
her alone.
understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
You are, Your Honor.
Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
I didn't.
Did you understand you're charged with possession of a controlled substance, penalty group 1, 4 grams to 200 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reasons your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison and up to $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
In my opinion, she is competent, Your Honor.
All right. And do you believe she was sane at the time of the offense?
Yes, Your Honor.
Ms. Bustos, has anyone threatened you, coerced you, or placed you in fear?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,000 fine and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea.
Yes, Your Honor.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that you deferred adjudication be for a term of 5 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Yes.
State, any evidence?
No objection, Your Honor.
State you may continue to confer. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am, I did.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments, and the court will review the same.
Yeah, sure reviews that. I don't know where this is going to go on the end. This is a hot tip from Weather Watch for this one, down from his home state of Texas. I did watch the bond hearing. I was working on the audio from Gigi, and I found that there's another.
All right, after reviewing state's
better audio.
exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I would like to ask the court to some assistance with the fine. The state has already lowered the fine, so she can.
I'll probate the fine.
Okay, thank you, Your Honor. And also, she needs some help with drugs, Your Honor.
All right. Do you have any children?
I did. I got 2 of them that are already old enough, 18 and 19, and then my 2 youngest passed away. So no.
I'm sorry about that.
Thank you.
All right. When's the last time you had employment?
Oh, no.
2019. I'm actually applied for disability.
All right. And what is your disability for?
I have mental illness
And what?
arthritis, 3 types of arthritis, and the mental illness.
All right. You know, drugs is not helping that, right?
Yeah, I know. I've tried getting off. The withdrawals hurt really bad. I'm tired of it. I really am. I do it only just because of the pain, but I'm trying to get off of it. I do need help.
All right. So who is Melissa Marie Barrera to you?
That's my cousin's baby mama.
Okay. I have to do the mental gymnastics. And who is Mark Anthony Bustos?
My cousin.
All right. And who is the person you're with in court today?
That's my boyfriend.
All right. Where is he?
Right there.
All right. All right. Thank you. All right. And do you have any family support?
Just him.
Where's your family?
My mom died, my dad died. Pretty much everyone passed away. I have my brothers, but one's in prison. The other one I don't talk to. So he's my family.
So that's why we're asking the court for some assistance, Your Honor. She needs some support from this court in order to help her with that addiction.
All right. This is what the court, and if you're drug tested today, it's going to be
It's
positive.
gonna be positive, man.
All right. I appreciate your honesty. Now, I'm going to give you help today, and I know you're probably going to get upset with me about the help that I'm going to give you, but I'm trying to save your life because the last time you use may be the last time you use.
Okay.
So I'm going to do $1,000 fine. It's going to be probated. I'm going to give you 6 years deferred adjudication, proof of employment, or SSI within 30 days. There should be no employment as a home health care provider or with minors. There should be no unsupervised contact with minors. There's going to be regular reporting by Zoom or in person. We're going to do the UA hotline.
I love that the judge gives the help they need.
Going to do a TAP evaluation, felony drug court referral, and Esperanza court referral. That's going to take place in custody. I'm going to ask for 120 sober meetings in 120 days. There should be no contact with Melissa Marie Barrera, Mark Anthony Bustos, Gonna want field visits one time per month until further notice. And 200 hours of community service restitution. Probation, is there anything else she needs?
Referral first.
Yes.
Pending outcome. I can't have two referrals.
No, we'll do felony drug court first.
Okay.
And if she's not accepted there, which if you're honest with them, they'll accept you.
Okay.
And then if she's not accepted there, we'll do Esperanza Court. All right.
Nothing further.
All right. Is there anything else you need from the court?
No.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, I did.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. To be we're off the record. To be successful in this court, you need to make sure that you're in contact with probation. If you feel it as though probation is not addressing an issue with you, you can always come in this court. We'll be here.
Okay.
All right. The other thing is felony drug court is a good program. It's something that you need. You're probably going to need inpatient treatment. But if you are accepted to felony drug court will be monitoring your situation. And they have a judge there, and that judge is Judge Glenn. He'll be monitoring how you're doing. The only time I will see you is if you're graduating, and I'll show up to your graduation, or if they send you back here because they say there's nothing else that they can do.
Okay.
All right.
Okay.
And if you want me to show up at your graduation, I will definitely show up to your graduation. Okay.
Thank you.
So what's going to happen today is the deputies are going to take you into custody. If there's anything that you want to see, want to give to your boyfriend, just let them know.
How long is it gonna be?
Yeah.
Because one, you already admitted that you're on heroin. That's not a good thing, because the last time you use could be the last time you use.
Okay.
And because here's the thing, if you could have, you would have at least came in the court sober. So what will end up happening is felony drug court, it's Tuesday. They'll probably be able to get to see her because I'm going to sign the order immediately for them to interview you. So they'll probably be able to see you before this week is out, and you need to let them know that you're interested in being in their program, and then they will take over supervision. If they think you need inpatient treatment, they'll give you inpatient treatment. If they think you need outpatient treatment, they'll give you outpatient treatment. Okay. So you're not going to be there for a month before something happens. So at the latest, felony drug court may interview her next week, but since it's early in the week, they'll probably be able to interview her. And I'm going to send them an email if you have no objections to let them know that she's on her way.
Okay.
Okay.
All right.
All right. Thank you.
Thank you. Thank you, Anna.
You're welcome. Thank you so much. Always good seeing you. And then Kelly, if you'll come up.
Okay. This judge has seen a lot.
Appreciate it.
Hi, you're probably next.
I don't
This
know,
is the
Judge.
deck I have. Who do you
It's
have?
not a plea, Judge. We just needed to make an announcement. I have Renee Roman.
Okay, just give me a moment. Let me take up Kelly.
That's fine. Thank you, Your Honor.
All right, Mr. Stokes, come down.
Sorry. All right.
Okay, just one moment. All right, so on Mr. Stokes, what did the bondsman say?
The bondsman said that they cannot send over a motion to reinstate bond. because
Okay.
of law.
Well, no, I mean, what the thing is if I recall the warrant, that means they're going to be on the bond.
Correct.
So
They're okay paying.
They're okay with being on the bond.
Okay, I'm going to bail from Judge Boyd right now. I love Judge Boyd. I love how she always has that person who's before their best interest. And if that person does not have their own best interest at heart, she's going to do what she does best, but she's also going to make sure that other people are safe. I love how she orders parenting classes at the drop of a hat for anybody who might in any way be associated with the raising of children. But we love her. She's amazing. And she has great flowers. So we sent her some. All right. We are going to, I wonder how she did. I do as well. She gives out parenting classes. If you have the potential to be a parent, she pretty much gives out parenting classes. It was just wild. All right. Great flowers, great purses, and amazing judicial temperament. All right. I don't know if you saw my earlier message. I got my magnets and stickers today, now proudly on my fridge, laptop, and Chromebook. Got spares for hubby's toolbox at work. That is awesome. Thank you very much, Sloth Life. Appreciate that. Today I ordered something from Sticker Mule. They make good stickers. They make good magnets, and they make amazing hot sauce. Now, this is not Ian Runkle level hot sauce. They have something they call mule sauce. And when I ordered as many magnets and stickers as I did for you guys, they gave me a free trial bottle of hot sauce, and I've used it up. It's so good. It's like a sweet Tabasco, is all I can say. That's where it's like. But I just ordered 8 more bottles because Sticker Mule, I won a contest on Twitter, and they gave me a credit that would pay for 8 bottles of hot sauce. so I'm super excited about that. Yeah. Good part's when they come by to say thank you. I love that when people come back into court and tell a judge, thank you for locking me up. Thank you for making that, what I thought was the worst day of my life, because you saved my life. And we don't see it a lot, but occasionally we get to see it, and it's amazing. OG Boy Mama, congratulations on 7 months. Dr. Bullbutter says, I never got a sticker. How do I do this? Well, here's your sticker, and I'll just reach it out to you, grab it, and no, just kidding. If you send me a self-addressed stamped envelope to the P.O. Box, I will cover the cost of the sticker and mail you a sticker back. Or if you'd like to buy 10 of them, you can go to Sticker Mule, and they have, for a reasonable fee, I think like $1.30 each, or right around $1 each, I think. You can buy a pack of 10, and they ship them for free. So, at least in the United States, I'm not sure if they'll ship internationally for free. Let's see. Anything else to go over today? I have to tell you, I need to film something. I was asked to film a couple short videos for a commercial. I'm not sure if it's going to be used or not, but I need to film something, and it might just maybe be on Court TV. So that would be cool. I'll see if I can put something together for them that matches what they are requesting, and if they decide they like it, then that would be cool. So I need to do that this afternoon, and then we expect to be picking up court on Monday. I turn Recovery Addict up and court down when it comes back on. Anyone else? That's my fault. Sorry, I could boost my volume if you want that, but I set the levels based on a professional audio meter is all I like to have mine about right here, which is right about -10 dB. 0 being max volume. Anything above 0 would be clipped and cut off. I like to hit right about -10. So if I get really loud, it doesn't go and blow out the sound. But all right. Don't forget us little people. It's just a commercial. It's just a commercial. That's all. And it's just a free collaboration. It's not anything fancy. Okay. I have a 4:45 p.m. alarm set with your name on it for my reminder to remind you to get that recording done. Thank you, Amber. I appreciate that. I do also have a meeting with YouTube on Monday. And I'll say this about YouTube. A lot of creators give YouTube a lot of hate because, the notifications don't go out, or a lot of people say, I wasn't notified, and that seems to be the biggest complaint. And then the way that gifts are given, we've got complaints about that. I have to say, YouTube has been amazing for me. It's been really good. I realize it has those issues, but I'm super impressed with the way they include content creators in the future things that are coming up on the channel. So they give you an opportunity to say, if you would like, we'd like for you to be in the test group to test new features. The flip side of that is there's a non-disclosure agreement, so I can't tell you anything that YouTube has coming up that I've been testing, but I get to talk to them on Monday about some new stuff. So that's awesome. Court TV visited your stream. They did. It was awesome. Saw them in chat. And then they emailed. Anyway, so I've got that. That's going to be Monday evening or Monday afternoon. I think 4 p.m. on Monday. So I've got to do a live thing with YouTube then. So blame you instead of YouTube. Got it. Well, that's not what I was saying, but you could if you wanted. I'll take the blame. He forgets about me. You're so privileged. Good for you. No, misconduct. I don't forget about it. I don't forget about anybody. We are trying to grow the channel a little bit, and some of the things I'm doing might help that. But the growing pains, I think, will be good. I think overall we're going to meet new friends, find new people that are near us and have great, insightful opinions and interests similar to our own. So that's where I'm going today. And it's sunny outside. It's beautiful. It's a Friday. We've got the whole rest of the afternoon ahead of us. I'm going to eat this lunch and get some filming done. I'm not going to come back after lunch. Are you interested in the sleepwalking twin murder trial? Oh my goodness, that sounds like a movie in the making. Text it to me on the burner phone, Warrior Queen, and I'll look into it. I've just been eating more to grow the channel. As you can see, Adam, I've got 2 plates for that very purpose. We've had ice falling off our house, crashing down on the deck and stuff, so it's pretty cool. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again Monday morning, hopefully, with the new trial. Should be in jury selection. We'll check. Hopefully. Fingers crossed. Fingers crossed. You guys, have yourselves a great weekend. Thank you very much. It's been an incredible week. Welcome to all those who are new to the channel. Thank you for clicking the subscribe button. I hope I can earn your continued eyeballs that you continue to watch and participate in chat. It would be wonderful. Where's the sleepwalking twin trial? I don't know. I've got to find out about that one. All right, guys, have a fabulous afternoon. Have a great weekend. We'll see you.
Because he's the guy.